Orders. Now, fresh.
No, I'm making a prayer for orders, Your Lordship. The sons.
So what is that matter? It is already on board. Notices issued.
Yes, my Lord.
Also, the
I filed an IA that
before you argue on execution, read those two judgments. Okay.
Yes, that on basis of that only I am praying that Your Lordship is.
Which basis of which?
That Your Lordship declining means in recent judgment of Honorable Supreme Court, execution cannot be stayed.
There are leading judgments. 141, 142, they have issued guidelines circulated throughout India.
Yes, I am just forgetting the name.
And
yes, the execution cannot be stayed.
Periamal.
Again.
So read those. So you secure the best defense in execution is that securing the amounts.
Yes, Your Lordship. And it has not been done.
But our strategy is that instead of securing, arguing.
My Lord.
And that too without any pleadings or any evidence.
So in this case,
that has to fail.
10 lakhs area is there, and the son is the opposite party, father is the petitioner.
In Sambalpur case, the mother was the opposite party, the son deposited around.
Again.
There was the direction was 4 lakhs, but he deposited around 2 lakhs.
Here it is area of 11 lakhs. 1 lakh has been deposited.
You are for the mother.
I am represented by mother. Minor son represented by mother.
So why you are seeking intervention of the High Court? High Court cannot execute a decree.
That has been stayed, my lord.
By this court?
Yes, Your Lordship. No, not by Your Lordship. But
Lordship Lordship is nothing. By this court is important.
Yes, Your Lordship.
You serve copy of that. I hear a copy that you serve korantu.
Yes. Any date on orders, Your Lordship may bring.
Orders is
again.
Say he is showing now, board is showing 18 has reached 117.
Again.
So you have festivities on the last week, including the last working day. Page wise call karantu.
Supplemental list, page 1, 2 to 4.
2 to 4 upon the 7 now. 3 plus 4, 7. Right. How can that be?
Page 2.
Pardon to mention my item 3, Lordship. Kindly taken over after vacation, Lordship.
You are Mr. K. Sethi.
Yeah, Lordship.
K. Sethi for the petitioner. The matter has been adjourned by the petitioner on 15/1/2026, 17/3/2026, 9/4/2026. Today, the matter being listed for fresh admission is mentioned at the beginning of the day's proceeding by the Lord and Counsel for the petitioner seeking adjournment to grant further opportunity. The matter shall be listed in the week for fresh admission in the week commencing 13/7/2026.
Okay, Lordship.
Yes, please. Item 2. Yes, item 2. The matter is pending since 2023, being presented on North in Kudiyapesi. After 3 years, adjournment is sought for on behalf of the petitioner. Earlier, the matter was adjourned by the petitioner on 23/26, 11/3/26. And on 9/4/26 it was adjourned. After here, the matter was heard at some length. The reason of keeping the matter pending for more than 3 years and seeking adjournment is inexplicable, to say the least. But today, the matter being in the list is mentioned at the beginning of the day's proceeding by the Lord and Counsel for the petitioner seeking adjournment. Apanko na, sir?
Chittaranjan Misra.
On behalf of the Lord and Counsel for the petitioner seeking adjournment. The Lord and Counsel is apprised of the order dated 9/4/2026, particularly paragraph 2, wherein the submissions were noted and the petitioner and the Lord and Counsel is to advance further arguments. Stop. To grant further opportunity, list in the week list for fresh admission in the week commencing.
There, sir.
There, sir.
My lord, item number 6, I am for the
The
petition.
copy of this order shall be forwarded to the Learned Judge Family Court Khurda to be kept in the records of criminal petition number 208 of 2015. Correct? Forwarded by the registry. Yes, next.
May I please your
Page
lordship?
2,
Item 7.
type
Page
2,
1,
until
Page 2, my lord.
page 2.
Item number 6, my lord, I am for the petitioner. My lord, in this matter, the petitioner had preferred
This,
P. Patnaik.
says, your name is not there.
Prakriti Patnaik, P. Patnaik.
Yes, yes. Prakriti Patnaik for the on behalf of
Petitioner.
the petitioner.
My lord, the petitioner had preferred an SLP, which we got to know last Friday that it got dismissed. My lord, we are
Anyway, that is
seeking some
the.
time.
I'm not asking anyone who has filed SLP or
Seeking some
I
time
don't-
to seek instruction.
whatever. The matter was heard extensively. This 19.3 order,
Yes, your lordship.
SLP number.
Uh,
SLP number note karo.
I'll just give them. Seven six nine two of 2026.
SLP diary or civil appeal or be specific because.
A
See,
special
and-
leave application. See.
Can you just please write it in a piece of
Yes, your lordship.
kagasta deal. Who ordered against it?
19.3.
Or like
Obliged.
who senior advocate was engaged?
No, your lordship.
So the cost of moving the SLP and all these things, if you compare with the ladies here, the lady and the child, that perspective.
Lordship, we'll just.
Because
need some-
recourse to judicial remedy, to my understanding, is a basic feature. Everyone has a right to approach it. If you read, it's a basic structure of the constitution. So there's no difficulty there. But if you make a cost analysis, perhaps.
We shall do.
Anyway, let's see different. On 19/3/26 and the facts as well as the issues in law were noted. The petitioner had adjournment. Thereafter, the matter was adjourned by order, adjourned by the petitioner on the ground of thereafter adjourned by the Lorded Counsel for the petitioner on 16/4/2026, stating that he will obtain instruction with reference to the order dated 19/3/2026. The matter today, the matter being in the list is mentioned by the Lorded Counsel for the disposal dates ଦେଇଛନ୍ତି
Nice.
ସେଟା ଦେବେ ନା petitioner seeking adjournment. So it is stated that the petitioner had opted to challenge the order dated 19/3/2026, filing SLP number 8, which has been dismissed by the Honorable Apex Court. Stop. They submitted by the Lorded Counsel for the petitioner that further instructions from the petitioner are necessary and the matter may be adjourned. Matter being in the list of fresh admission, সেটা lecture তো সেটা সবুতরে রয়েছে রিপিট না করলে লিখি to grant further opportunity to the petitioner when
My lord, after vacation anytime.
list for fresh admission in the week commencing
13/7.
13/7/2024. Mr. Bipin Kumar Nayak for the petitioner. The matter was heard at length on 13/3/2026. The council had adjournment. The Lorded Council had adjournment to obtain instruction in terms of the said order, which had noted the facts as well as the legal issues. Stop. Thereafter, on 9/4/2026, the matter was adjourned by the petitioner. Stop. Today, the matter being in the list is mentioned at the beginning of the day's proceeding, seeking adjournment. Stop. By the Lorded Council for the petitioner. Adjourned. To grant further opportunity, the matter shall be listed for fresh admission in the week commencing after
20/7.
20/7/2026.
Item 8 to 13. Page 3, 14 to 18.
Serial number 18, my lord. I'm for the opposite party, my lord, in this case, my lord.
Again, opposite party.
I'm from opposite party, my lord, in this case. Already I have filed
Yeah.
with.
Petitioner के नाम थी
Already I have taken instruction, my lord, for short adjournment, my lord.
बुझिपारे
Already I'm at instruction neji petitioner advocate for already.
କାହାଠୁ ନେଲେ ନା କ'ଣ
My lord, Adyasit Mishra. Office.
ଏଇଟା ଆଇଟମ 18 ରେ ଆଦ୍ୟସିଦ୍ଧିଙ୍କର ନାଁଟା ଏ ମିଶ୍ର ହଉଛନ୍ତି ଆଦ୍ୟସିଦ୍ଧି
Yes, my lord.
ତାଙ୍କ ନାଁ ଲେଖିଲେ ହବ
No, no.
ଆରେ କାହାଠୁ ନେଲେ ଇନଷ୍ଟ୍ରକ୍ସନ ତାଙ୍କ ନାଁଟା ଲେଖିଲେ ହବ ବୋଲି କହିଲେ ନାହିଁ କରୁଛନ୍ତି କ'ଣ ଇଏ ଆଦ୍ୟସିଦ୍ଧି
A Mishra, A Mishra.
ଆଁ?
A Mishra.
ଏ ଆଦ୍ୟସିଦ୍ଧି ତ
Yes, my lord.
ହଁ ୟେସ୍ 18 ଟାକୁ କେବେ ଚାହୁଁଛନ୍ତି
After vacation, my lord.
ନା କେବେ ଲିଷ୍ଟ ହେଇନି ଫାର୍ଷ୍ଟ ଟାଇମ ଅର୍ଡର୍ସ ପାଇଁ ଆସିଲା ମେମୋ
Release there, my lord.
ଆଜ୍ଞା The matter was heard at 18 ଲେଖିବେ the matter was heard at length on 18/2/2026 and was adjourned after noting the facts as well as the legal evidence in brief. Stop. It was adjourned by the Lorded Council for the opposite party on 19/3/2026. Stop. Today, the matter being listed for orders is mentioned. You are Mr. Jatti.
Yes, my lord.
It is mentioned by the Learned Counsel for the opposite party seeking adjournment. Stop. He states that he has obtained consent from the Learned Counsel for the petitioner. Stop. Accordingly, the matter shall be listed for orders in the week commencing
My lord, after vacation.
6/7/2024.
Yes, my lord. Obvious.
14 to 18 ଆପଣଙ୍କର ତ ପରିଯାଏ
This particular item 4,
4
my lord.
ଟିକେ ରୁହନ୍ତୁ
Twice I have taken time. Last occasion it was non-appeared. I pray, my lord.
ଟିକେ ରୁହନ୍ତୁ
Again.
you are in a hurry. Just give us a moment.
Page 4, 19 to 24.
Item 23.
23 after notice. You are for
I'm from petitioner. ma'am.
inform the other side because they will be reaching at
Yes, yes.
today there is that special bench continues
Yes.
and
My
also assignment after court hours.
I'm for the opposite party.
So you are agreeing for a date, suggested date since he is the case. କଣ କରାଯିବ sir? 2019 whether you would have engaged me then I would have finished it. So as a lawyer now I cannot do anything. Anyway, it's in lighter weight. Why should you engage me? 2023 ଟାକୁ
Vacation any-
ଶୁଣନ୍ତୁ ସେଇଟା ତ ଉପରକୁ ଆସୁଛି ନା ଆପଣଙ୍କ ଆଇଟମ ସିରିୟଲ ନମ୍ବର 2 ରେ ଅଛି ଟ୍ରିବ୍ୟୁନାଲ କେ ପ୍ରାକ୍ଟିସ କରିଥିଲେ ୱେଟ୍ ରେ ଆପଣଙ୍କର ହିୟରିଂ ଲିଷ୍ଟ ରେ ମୁଁ ଗୋଟେ ବହୁତ ମେନସନ କରି 20 years back 20 years ବେଶୀ ହବ 25 ବର୍ଷ ହଁ 25-24 ବର୍ଷ ହେଲାଣି ପୁରା ମେନସନ କଣ୍ଟିନ୍ୟୁଅସଲି ମେନସନ କରି ସେ ଆପଣ ଟପ୍ ଅଫ୍ ଦ ଲିଷ୍ଟ ଆସିବ ଟପ୍ ଅଫ୍ ଦ ଲିଷ୍ଟ ଏଟା ଆସିଲା ଆପଣଙ୍କର after notice ର top ରେ ଆସିଲା ଠିକ ଆଉ କେବେ ପଢିଲାନି so I had told the client he said, now has become a profession. He was young then, so he said that case will continue, but he gradually got promotion, maybe he'll be retiring. Another by 60, so he'll be retiring. Some of my young friends, he also said that your matters in tribunal, if they are languishing, then after transfer, then give us to us, then we can revive them. I don't know what happened. So ଆପଣଙ୍କର 2 number ରେ ଅଛି actually. It starts at 22, ଆପଣଙ୍କର 23. My point is that don't be disappointed because उन्हीं salary ତ ଆସୁଛି ତ second item ଅଛି ରଖନ୍ତୁ କେବେ ଆପଣ suggest କରନ୍ତୁ date ସେ କହିବେ ସେ ଚାହୁଁଛନ୍ତି date ଆପଣ suggest କରନ୍ତୁ it is your choice. After vacation କେବେ ସେ 6, 7, 13 ଏମିତି ଦଉଛନ୍ତି ସେ 29/6 ରେ 6, 7 ରେ 91 29/6 ରେ 71 76 କରିସାରିବେ ଠିକ ଅଛି ଆପଣ ଦିଅନ୍ତୁ ଜଲ୍ଦି କର
6-7
6, 7 yes
page 5 25 to 31
Well, it's item number 29, my lords. I am for the
29.
petitioner. Well, it's last occasion you also part allowed my IA for amendment of the writ petition, my lords. Pursuant to which I was to file the
consolidated ଟା କରିନାହାନ୍ତି
no, my lords. I pray.
କାଉଣ୍ଟର ବି ହେଇନି
My lord, intentionally they are harassing 10 women.
ଆପଣ ସେଟା କହୁଛନ୍ତି ସାର୍
ସେ ଆଗେ on technical ground ବାରମ୍ବାର ନଉଛନ୍ତି ସେ ଗୋଟେ ସରପଞ୍ଚ ତାକୁ ମାଲାଫାଇଡ ଇଣ୍ଟେନସନ ରଖିକି ସ୍ତ୍ରୀର
Sir, pain is always matter than sword.
ଆଜ୍ଞା
Pain is always matter than sword. ଆପଣ ଯେତେ ଲାଇଫ ରେ ବସ୍ ମାନେ you grow old you will realize that. So ସେଥିପାଇଁ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି ସେ ଯିଏ ବି ହୁଅନ୍ତୁ ଆପଣଙ୍କର ଇଏ କରିବେ ଆପଣ କାହିଁ ଫାଇଲ କରୁନାହାନ୍ତି ଡିସମିସ୍ କରିଦେବା ନା କଣ
No, my lords. I will file in the
ଆଜି
course of
କରନ୍ତୁ।
the day. ଆଜି କରନ୍ତୁ।
ଠିକ ଅଛି
ସେ ତାହେଲେ ରଖାଯାଉ ଡେ ଆଫ୍ଟର ଟୁମୋରୋ
after tomorrow କଣ ହେଇପାରିବ you must understand the list is packed. Sir, unless I hear those fresh and orders matter, those are interlocutory applications. There is a method. Here the court is overburdened also to certain extent as far as अरे RPFM TRPC ଯଦି hearing ହବନି ଆପଣ ଭାବୁଥିବେ ଯେ ସେଟା ତ hearing ହଉଛି ଆମର ହଉନି but ସେଟା hearing ନ କଲେ କେମିତି ହବ there the pending suit is interdicted ଆପଣଙ୍କର at least adjudication ପାଇଁ ଅଛି this is the court of first instance.
from 2023 November 10 ଜଣ ସ୍ତ୍ରୀ ଲୋକ harass
Sir,
ହଉଛନ୍ତି
I understand harass
repeatedly ସେମାନେ ତାପରେ ଏମାନେ
ତାଙ୍କର ଇମୋଟିଭ ଇଏଟାକୁ ଆପଣ ପ୍ରେଜେଣ୍ଟ କରନ୍ତୁ ଆପଣ legally sound ରୁହନ୍ତୁ ତାଙ୍କୁ ଆପଣ କହିବେ ଆଜ୍ଞା this is a difficult path they have opted legal path
my lord my name may be deleted ମୁଁ ତାକୁ ଫାଇଲ
ସେଇଟା deleted ଆପଣ
ସେ ମତେ କହୁଛନ୍ତି ଆପଣ ବୋଧେ
ସେଇଟା ଆପଣ ଶୁଣନ୍ତୁ ସେଇଟା ଆପଣ କୋର୍ଟ ଡାଇରେକ୍ସନ ଆପଣ ତାକୁ କହିବେ ଯେ ଆଜ୍ଞା କୋର୍ଟକୁ ସେ ଡାଇରେକ୍ଟ କରିପାରିବେନି ଡିଲିଟ କରିବା ପାଇଁ ଆପଣଙ୍କ ଚଏସ୍ ଆପଣ ଆର୍ଗ୍ୟୁ କରିବେ ନ କରିବେ ଏନଗେଜ କରିବେ କୋର୍ଟକୁ ଡାଇରେକ୍ସନ ଦେବେନି ଆପଣ ଯଦି ବି କହିବେ ସିରିୟସ ମୁଁ ରିଜେକ୍ଟ କରିଦେବି ଆପଣଙ୍କ ପ୍ରେୟାର if you want I'll record and reject it you want that choice sir
last time
sir ଏଠି ଶୁଣନ୍ତୁ ମାନ ଅଭିମାନ କରନ୍ତୁ
no lord
ଶୁଣନ୍ତୁ ଆପଣ ଯଦି ମାନ ଅଭିମାନ କରିବେ ଆମେ ତ ଭଗବାନ କୃଷ୍ଣ
no stay there is no stay of
problem ଆପଣ sir you are attributing so many things to the other side you do your part as a lawyer instead of attributing ଆପଣ object କଲେ I told him that he is objecting what is there ଆପଣ ଯଦି କରିବେନି then I'll reject I'll record your submission that you are saying my name may be deleted I'll say that the prayer is rejected because the court cannot delete anyone's name none of the you must understand you are sufficiently senior whenever you are making a prayer before the court you are being watched apart from those 10 ladies you have so many thousands of clients who are watching you thousands of your colleagues are watching thousands of judges are also watching please don't make this is not a emotional
I mean pardon
why should you be pardoned what you have done wrong
there is no stay order but 30 this
sir
is the 33rd time
sir when there is a
filing again
you must understand that I am not the sub collector you tell that before the sub collector you must understand that is how I told you that pen is always matter than the sword if you say that you file an application that court has granted them the PDS license file that application that High Court has granted then it will be considered don't make it farcical emotional farcical does not help OTT platform रे जेते देखिबे सेते concept खराब हे जो argument you want I'll say serious I'll record it yes you want that your prayer should be recorded
let it be my lord next week
no ଆପଣ ଆଗ ଗୋଟେ କାମ ସାରନ୍ତୁ next week गोटे काम आपणकर ना डिलीट करिया कथा रेकॉर्ड करिकि रिजेक्ट करिवे ना नाही विथ रीजंस ना नाही आपण कोन चाहुछन
नेक्स्ट वीक आसु
केबे नेक्स्ट वीक आपण रखि पारंती इट्स योर चॉइस आपणकर ना सर
G Das my lords.
पण केतबे ऑलवेज ट्राई टू आपण एडमिनिस्ट्रेटिव लॉ पढले इरिलेवेंट कंसीडरेशन पढाला आपण मोस्ट इरिलेवेंट कथा एटी कहिबे आपण क्लायंट कोन आपण चेंबर रे कहिले से केते रागी गले केते रुसिले ब्रीफ नहीं गले यू शुड बी कॉन्फिडेंट सर ब्रीफ दे दियंतु आपण सह ब्रीफ आसीबो यू आर मच अबव तांकोटु बहुत ऊपर अछन आज्ञा
G Das my lords.
Mr. G. Das for the petitioner, item 29. Mr. Why should you be? Sir, you are not at all, sir, देखो सेटा कहले मो कहबिनी तार I'll stop telling the truth on your face.
No, I'm sorry.
If you, why should you be say sorry? आपण कोन भूल कले जे sorry कहउछंती I am sorry that you are saying sorry. That much I can say. आपणकर जो एंटिक्स गुडा आपणकर चैम्बर रे करछन्ती अछि आपणकर क्लाइंट से एंटिक्स एठी करिवेन दैट इज हाउ यू आर वेयरिंग कोट एंड ग्राउंड एंड बैंड एंटिक्स बेस्ड सबमिशन हवन एंटिक्स ड्रामा ऑल दिस थिंग्स इमोटिव इश्यूज हमर पीडीएस लाइसेंस हरासमेंट कोन फंडामेंटल राइट टू गेट ए पीडीएस लाइसेंस कैन यू आर्ग्यू आपण देखो सुनंदो आपण बुझिवा दरकार आपण जो दिन आर्ग्यू करिवे एटा आर्ग्यू करिवे ना छाड़ देबे आर्ग्यू करिवे develop your argument like that. To get a PDS license is a fundamental right. Fundamental right is violated. Those are to be considered by the court. Throw it to the court. Let the judge handle it, whether it is a fundamental right or not. अब ये ऐसे कि आपण से चैम्बर रे कहउछनी ब्रीफ नै छु हम हैरान होछु. What is this? And you must know, sir, legal practice is about 90% strategy, 5% efforts, and no reading. Yes. Sir, you are better actually. Sir, execution matter, execution matter, nobody is doing anything. Simply filing it 10 वर्ष पर्यंत पड़ी की रोज 2016 रे गोटे आरपीएफएम 10 आईए फाइल स्टे करिया ट्रायल कोर्ट रे कहै हाई कोर्ट रे पेंडिंग अछि आई कैन गिव यू द नंबर आल्सो ना तो मन अछि तो नंबर भी बाहर तो एटलीस्ट आपण द पीडीएस लाइसेंस आपण पे व्यस्त होछ दैट इज सर
एक्चुअली
सर दैट इज द यूजुअल थिंग
घरटे निसंदी यूथ पे पर मंथ्स
से घर छाड़ देबे आपण सेतिर काई पछुन सर आपण लेवल रे रहबे कोन काई पछुन ताकर कोन पर्सनल डिफिकल्टीज आपण केस करिवे
ना सीट पे
Sir, this is a general discussion, purposefully general discussion. There are so many hardships for a lawyer, and ताजरे आपण अन्य मान के इमोशन आने भर्ती करिवे. से कहिबे, but you have to take everything with you. You have to take everything in your stride. Legal strategy is always there. कौन से legal strategy होबो कोन अछि आपण सुनले गोटे फ्रेश एडमिशन मैटर रे भी एसएलपी फाइल है काहे की पिटिशनर तो भाबिथियो जे नाही आई हैव ए केस just now. So that is possibility. See the SLP file करे आपण रागी जे पाए जे SLP file कले हम हैरान होछु. फिर लिखली for the petitioner Mr. SC Pradhan for the
opposite
on series रे के Mr. Prem on this के अछन
Mr. Prabhu is there.
Mr. Prabhu तीसरे मिस्टर प्रभु प्रसन्न बेहरा एडिशनल स्टैंडिंग काउंसिल फॉर द अपोजिट पार्टी 1225 है ना मिस्टर एससी प्रधान फॉर OP6 the matter is mentioned by the learned counsel for the petitioner. The matter being in the list for hearing, the sentence change for the matter being in the list for hearing under the heading for admission is mentioned by the आपनको रिक्वेस्ट ही एटा फॉर एडमिशन रे अछि नले एटा हियरिंग रे जिबा कथा ऑलरेडी आपण हियरिंग चली छि एतरे सो कोर्ट जेती करि परिबो ना हियरिंग होला तळु पळे आसु Only,
Well, I may pardon, Mr. Ansuman
okay,
Shetty is there.
okay, Mr. Ansuman Sethi. Additional study. Only. I listed for hearing on, under the heading so and so is mentioned by the learned counsel for the petitioner. Stuff. He refers to the office note put up by the registry, indicating that the order dated 6/4/2026, the pursuant to order dated 6/4/2026, the amended petition has not yet been filed. Additional counter ଆପଣ ଦେଇଛନ୍ତି ଆପଣ ବି କପି ଦେଉନାହାନ୍ତି
ନା ମୁଁ ଦେଇନି
କଣ what is this sir?
My lords, additional counter is to file by them.
କପି ଦେବେ ନା ନାଇଁ ଆଡିସନାଲ କାଉଣ୍ଟର ସିଏ କଣ ଫାଇଲ କରିବେ ଆପଣ ଆମେଣ୍ଡେଡ ପ୍ଲେନ ଟା ତାଙ୍କୁ ଦେବେ
My lords,
କୁଆଡେ ଗଲା
so I will file in the court.
ଆଜି
Aji.
କଣ ଲେଖ file on being asked the learned counsel for the petitioner submits that due to inadvertence he could not file the amended first petition as well as could not serve the copies. He undertakes to file the same within 2 working days. The order is peremptory. Failure to do so shall result in dismissal of the writ petition in limine. Stop. The learned counsel for the opposite party number 5 expresses grave concern. Number 6. I thought his brain so he will not express. 6 expresses grave concern regarding the adjournment. Stop. The additional standing counsel as well as the learned counsel for the OP6 shall have liberty to file their response to the amended petition. You want this next week? The matter shall be listed for admission next week. Yes, in the week commencing, week commencing 18/5/2026. Yes.
Blessed.
Yeah, again, upload.
Page 6, 32 to 40.
Item 34, my lord.
Is put that.
34, my lord, any date, my lord.
So Das, 34.
I have some difficulty.
He has informed me in the morning, my learned senior has informed. Only my request is, Lordship may record my objection
Okay.
to that. Because
So
on the last
Sahoo
occasion,
for the petitioner, Mr. Praveen Das for the opposite party, 34 Lekundu. The matter being listed for hearing under the heading for admission is mentioned by the learned counsel for the petitioner seeking adjournment on grounds of personal difficulty. Stop. Para, the learned counsel for the opposite party opposes the prayer for adjournment. Stop. However, to grant further opportunity to the petitioner, the matter shall be listed for admission.
my lord,
After vacation.
immediately after vacation, if I pray, my lord, because on the last occasion, Lordship,
Immediately, sir, it has gone to 91 and 76.
my lord.
So,
My
in fact,
No,
the
that
earliest
they-
possible, actually,
there-
this style of adjourning, very short adjournment
My
is
lord.
only unique to Odisha.
My lord. There is a stay order
You can't add
continuing, so
anything
that
else to
is,
the list. Same matter, godi kiri say adjourn ହେଇକିରି ଚାଲୁଛି. Anyway, ଠିକ ଅଛି.
Matter
ଯେତେ
already
ଜଲ୍ଦି ହେଇପାରିବ
or-
କର।
Week commencing 29.
We commencing 29/6, we commencing interim order as past. Interim order କଣ ଥିଲା?
but stay of,
Stay ଅଛି.
stay ଅଛି since last year.
Interim order dated that shall continue till the next date of hearing.
Pardon for mention, my lord.
32, my lord.
My lord, item 37.
My lord, item 32.
32.
I am for the petitioner. There was a direction to file a joint affidavit. The
Hmm.
party has not been able to come. You lordship adjourn it to some other day. There is chance of compromise.
ଆସିବ ଛୁଟି ପୂର୍ବରୁ ଆଣିବେ।
ଛୁଟି ପରେ ଆସିବ ଆଜ୍ଞା ପୂର୍ବରୁ ଟାଇମ ହବ।
So 32 ଲେଖନ୍ତୁ, say the matter being in the list for hearing under the heading for admission is mentioned by the learned counsel for the petitioner. He submits that he has intimated the learned counsel for the other side.
I am for the opposite.
Okay. Mr. Bhagavan Bishwal करतो, appearance करतो, Bhagavan Bishwal करतो.
The opposite party also presents.
It is submitted by the learned counsel for the appearing parties that efforts are on to file the affidavit, joint affidavit by the parties indicating the settlement acceptable to both. The further time is sought for. Accordingly, the matter shall be listed for admission in the week commencing 29/6/2024 ऑर्डर से आने में कुछ
Earlier orders has
for orders कर दो
interim order is to be
interim order as dated dash shall continue till the next date of hearing.
Pardon for mention, my lord, item 37. I am for the petitioner. My lord may kindly take up this matter after vacation. Item 37.
The matter being 37 to this is Lakshmi Sharma for the petitioner. Opposite party inform करचंती.
Again, opposite party is also
OP number
present here.
2 and 3, my lord.
Mr. 37 रे Mr. प्रेम किया अचंती.
Ansuman, ma'am.
37 Mr. Ansuman Sethi, additional standing counsel for the opposite party number 1. Mr. M.K. Ratha for the OP number 2 and 3. The learned counsel for the petitioner as well as learned counsel for the OP number 2 and 3 are present at the virtual court, High Court of Orissa.
Bargad district.
Again?
Bargad.
At Bargad. Sorry, I could not actually. I don't know why at Bargad. And address arguments. Stop. Adjournment is sought for. Commercial matter being listed for hearing under the heading admission for admission. Stop. Accordingly, the matter shall be listed for admission in the week commencing 27/7/2024.
Interim petition is there, my lord may kindly continue.
Interim order dated 26/11/2025 shall continue till the next date of hearing. Yes.
Item 40,
40, sir.
40, they have not complied, neither procuratorium has been filed. I have already served the copy on him.
40 what can be done, Mr. Ray?
My lord,
Item 40. You have received copy.
my lord, directed for instruction. I have taken instruction, but my lord friend has not solved the extract.
Dinali.
So copy କହିଲେ ଗୋଟେ ଦେବା ପାଇଁ ଆଉ ଗୋଟେ extra copy ସେ ମାଗିଥିଲେ।
State bholia. They have to send the copy. Upon you are still saving a lot.
Yeah.
Postal requisite darkar
And that,
nahi.
my lord, to be very frank, that day I served a copy saying that
Nahi, theek hai, I am not finding any issue. Nahi,
Lord,
exception kon?
I am anxious for stay.
No coursive action na kon?
No.
Stay house. About
No coursive action. My lord may.
So once. Mr. Mohito Sinha for the petitioner, Mr. Amarendra Prasad Ray for the opinion of opposite parties.
To whom extra copy served.
Yes, it's no difficult.
My lord.
No difficulty. The matter is listed for hearing under the heading for admission. It is submitted by the learned counsel for the petitioner that he has served copy on the learned standing counsel for the opposite party. Plural of opposite party, the opposite party singular. Stop. The learned counsel for the opposite party submits that he may be provided with an extra copy. Stop. To enable him to obtain instruction. For a copy of the extra copy served in the during the hearing of the matter in court itself. Stop. The learned counsel for the learned standing counsel shall obtain instruction and file affidavit. Amnesty Amnesty
No.
Achha. They'll obtain instruction in the matter and file affidavit if so advised. Okay. Upon serving copy thereof on the learned counsel for the petitioner. Stop. IE 6368 of 2026. Hard learned counsel for the petitioner. He reiterates his submissions as noted earlier. He submits that the order dated 25/6/2024 passed under section 45 as capital A of the USA Act, 1948, maybe state. Stop. State during pendency of the writ application. Stop. Para. In the interim, it is directed that no coercive action shall be taken against the petitioner pursuant to the order dated, orders plural, orders singular, orders dated, order dated 25/6/2024, passed by the opposite party authority. To bracket annexure 2 series. The matter shall be listed for admission in the week commencing 27/2024. Mr. A 27.
Much obliged, suspect.
See that लिखिए खास urgent certificate के ऊपर लिखिए the matter being in the list लिखिए mention लिख ले तो सेटा सब उठी छाड़ दो जो कि complete कर सकते is mentioned by the learned counsel for the petitioner stating the urgency and seeking interim order. Tell it. Urgent certificate.
Pardon, my lord.
Yes, please.
Page 16 is not continuation of page 15, my lord.
ये देखिए जो
Out copy दे दे.
एटा देखि दो ये एपट सपट है तो
उभय थेरे अछि से या एटा तार continuation order ର continuation एटा show cause notice ର continuation
ମତେ ଯେତିକି ମିଳିଛି ଦେଇଛନ୍ତି
से आपन क्लाइंट को पचारंतु से आपन को जेमती मिस्टर प्रधान को क्लाइंट काम करचंती सेमती से मिसै दे के आपन को दे देले
से show cause notice ର
show cause रू गोटे पेज ऑर्डर रू गोटे पेज देखि दियो आज
My lord,
item
item
परि जा पर ये स्पष्ट परि जा
item 4.
लास्ट पेज सरी वाला मैडम आपन को लास्ट पेज ले
No, my lord, page 3, item 20, my lord.
just once और रे कोन मिस्टर परि जा कोली
My lord, as I am remain present before your lordships, it was came non-appearance on that days, my lord.
यदि आपण अपियर करथिले भूल रे हिची ताले तो कहबे
Today,
थिले आ कहि लाभ कोन
today I pray, my lord, the case was, I have taken time for obtaining instruction. The matter regarding.
कोन 24 मसर इंस्ट्रक्शन नोचंती तो टिके बेसी हे जाउची हो दिबर्सल इंस्ट्रक्शन नोचंती
Last chance देला
लास्ट टाइम तो दिया जाइची
contact कर
this was in fact whenever a last chance is given what is the next order is a big issue and last chance is never a last chance as you know order 9 rule 13 तापर आउरी कोन अछि just give us a moment से आसो we completed 10-11 orders so you cannot complete if it is delayed he will not be able to come. ଆପଣଙ୍କର 20 ରେ कोन हो
Time name.
orders better fresh admission no
No orders.
ଆପଣଙ୍କର କେବେ ମିस्टर ପରିଚୟ ଚାହୁଛନ୍ତି आफ्टर वेकेशन केबे केबे
any day.
देखो तो एनी डे को दिन हो
We counting 6
आउ मैडम पटनायक आपनकर
बरे आरो इतरा फेस मास्टर टा मु खाली टिके चेक कर दे
नेक्स्ट वीक रे आसीबो
आरो
हाउ नेक्स्ट वीक इट हैज रीच्ड 120 ठीक है
आरो इतरे
आइटम 4 लिखंतु तो पीसी परिजा फॉर द पिटिशनर the matter the efforts of the registry to contact the learned counsel has yielded result. The learned counsel for the petitioner mentions the matter at the beginning of the day's proceeding, seeking further adjournment. Stop. To grant further opportunity to the petitioner, the matter shall be listed for fresh admission in the week commencing 6/7/2024 to enable the Lord Council to obtain instruction in terms of the order dated 2/2/2026. Reiterated in the subsequent orders. Stop. Yes. Then item 18.
Item 17, my lord, on behalf of,
Just ଟିକେ ରୁହନ୍ତୁ। Item 18. Item 20. Ms. Namita Patnaik for the petitioner. The learned counsel for the petitioner, the matter is mentioned by the learned, matter being listed for fresh admission is mentioned by the learned counsel for the petitioner, seeking adjournment, stuff, to grant further opportunity. The matter shall be listed for fresh admission next week. In the week commencing 18/5. So, Padi, after
my lord, on behalf,
After vacation, you'll also keep it.
after vacation.
On 3/6.
To be listed for fresh admission in the week commencing on 3/6. Mr. Padi, on behalf of
my lord, on behalf of SK Naik, my lord,
Mr.
after
Padi,
vacation.
you are Mr. Ikip.
SK Naik,
ଆପଣଙ୍କ ନାଁଟା SK Naik.
Manojan Padi,
Mr. You are writing MR or M Padi?
MR Padi.
Mr. M.R. Padi on behalf of SK Naik for the petitioner, Saptaray. None had appeared for the petitioner on 30/4/2026. And order dated 34/2026 was passed. Indicating that the matter shall be disposed of. Earlier, none had appeared on 9/4/2026. The matter was adjourned, intimating the petitioner, intimating the learned counsel. Directing the registry to intimate the learned counsel. After the matter was heard at length on 24/2/2026, for the last 3 months, the only effort of the learned counsel for the petitioner, the only effort of the petitioner is to adjourn the matter somehow or the other. Today again, Mr. Padi, learned counsel, submits that he has no instruction but has been requested by Mr. Naik to adjourn the matter.
His brother marriage, my lord, younger brother marriage.
You should have gone in Bharat. The most favorite you are, so you should go on Bharat. Why should you mention? Because that kind of work is done by the judge and the registry, because they can join the Bharat. No instruction, but has been instructed for seeking adjournment. The matter is adjourned to be taken up for fresh admission in the week commencing
On 3/6.
on 30/6. 29 ବେଳକୁ ଆଉ ଏଟା ହବନି, କାରଣ ତିଥି ସରିଯାଇଥିବ, ବୁଝିଲେ କି? ଅନ୍ୟ କଣ ଦେଖନ୍ତୁ ପ୍ଲିଜ। Yes.
Item 1.
ଇନଫ୍ୟାକ୍ଟ ଆଜି ବି ବାହାଘର କିଛି ନାହିଁ, ସରିଗଲାଣି। ସରିଗଲାଣି। ଯେତେବେଳେ ମୁଁ କହିଲି ସେଟା ବୁଝିଯିବାର ଥିଲା। ବାହାଘର ବିଲକୁଲ ନଥିଲା, ତାପରେ ବାହାଘର ବାହାରିଲା, ବାହାଘର ଯାଇଥିଲା ସରିଗଲା। ଆପଣ ବେଟର ପ୍ଲିଜ ଦେଖନ୍ତୁ ମିଷ୍ଟର ଶତପଥୀ, ଯୋଉ କ୍ଲିଉ ଗୁଡା
ରିସେପସନ ରହିବ, ବାହାଘର ସରିଗଲା 4 ଦିନ 5 ଦିନ ରିସେପସନ ଚାଲିବ।
ରିସେପସନ ସରିଗଲା ପରା, ମଙ୍ଗଳବାର ଆଉ ରବିବାର ସୁଦ୍ଧା ପ୍ରାୟ ସରିଯାଇଛି। ସୋମବାରିଆ ରିସେପସନ ଆଉ ହଉଛି କଣ? ହିନ୍ଦୁ ମ୍ୟାରେଜ ଆକ୍ଟ କମ୍ପ୍ଲାଏ ହେଇପାରିବ ନା କଣ? Yes.
I'm on VC, my lord.
Item 1.
Yes, madam. Item number 1.
You could achieve the mediation.
Yeah, mediation actually had taken place. That mediation report has not been given to me, Milan. A copy of may kindly be supplied. So the
mediation report
Last, let the get.
Say,
D.
Mr. Bhutti, anyone there in the virtual court at Jaipur? Assistant is there? Just
Yes,
ask.
my lord. Yes, my lord. Hey, ଆପଣଙ୍କୁ court master. Yes, he is my lord.
ଆଜ୍ଞା ଆପଣ ଯୋଉ ଇଏ ଆପଣ ଟିଭିରେ ଆସିବେ ନା ତ ଆପଣ କୋଟ୍ ଫୋଟ୍ ପିନ୍ଧି କୋର୍ଟ ମାଷ୍ଟର ଯେମିତି ଏଠି ବସିଛନ୍ତି ମିଷ୍ଟର ପ୍ରଭାତ ବାରିକ ଆପଣ ସେମିତି ଦୁସିବା ଦରକାର ୟୁ ଲୁକ୍ ଡିଫରେଣ୍ଟ ସେ ଯୋଉ କୋର୍ଟ ରେକର୍ଡରେ ଅଛି ଆପଣଙ୍କର ମେଡିସିନ ରିପୋର୍ଟ ଆପଣ ଦେଇପାରିବେ ଅର୍ଡର କଲେ
ନାଇଁ ନାଇଁ ସେ କଟକ it is not there, sir. He has sent it directly from DLS.
ସେଟା ହେଇଥିବ ଆମର ପେପରଲେସ୍ ସେଥିପାଇଁ ସେ ବୁଝୁନାହାନ୍ତି ସେ ପଳେଇଲେ ଫେରେ
ଆଜ୍ଞା ଆଜ୍ଞା ନା ଅଛନ୍ତି
ଆଜ୍ଞା ସେଇଟା ଯୋଉଟା ପେପରଲେସ୍ ବ୍ରିଫରେ ଅଛି ସେଟା ଯେହେତୁ ପେପରଲେସ୍ ଦିସ୍ ନଟ୍ ଏଇ କୋର୍ଟରେ ପେପରଲେସ୍ ବ୍ୟବହାର ହଉଛି ଆଇ ହାଭ୍ ଏ ସେଇଟା ଆପଣଙ୍କୁ ପଠେଇବାକୁ ପଡିବ ନା ଆପଣ ଡାଇରେକ୍ଟ ନେଇପାରିବେ ପଠେଇବାକୁ ପଡିବ
My lord, I can collect it from Cuttack itself, my lord.
It is a medicine Jaipur rahichi, so they can collect from Jaipur center also.
DLS secretary. If it is available, then I will collect it.
He says that report has been sent to Cuttack actually.
Office copyright pure medicine.
I don't know. ठीक ଅଛି
I will get it collected, my lord.
Office copyright. Like D, the medicine report that was failed.
That's what I find it, but it was not.
But still, it is worth an effort of doing it.
37.
Yes, my lord.
30%, 70% के party lead करी कर ले. Middle person 40-60 arrive कर ले.
This is a case where it should happen. Because they are staying at 600 kilometers away, they can't attend the case is kept pending. And apportionment, they have to be persuaded that they have to sacrifice a little.
Yes, my lord. That's what we have also advised.
For the appellant. Appellants, plural. Mr.
T.N. Murthy.
The state को party करेंगे Mr.
T.N. Murthy, my lord.
N. Murthy for all the respondents, sir.
Yes, my lord. Soe Mandinga. Only one.
एक रु साथ है समस्त को पे.
No, sir. Only one. Soe Mandinga.
अच्छा. Mr. T.N. Murthy for R1. You are appearing for any one of them?
No, sir, I was here to collect the copy just in case for mediation.
Okay. On my behalf, my lord.
Okay. Along with your name, madam?
SL Sinha.
Mr. S.L. Sinha, Miss S.L. Sinha.
Sir, appealing for 1 to 7.
Sir, कुछ नहीं जानूंगा मैं.
मैं एक भोकलर नामा अच्छी.
Oh. Yes, my lord. Yes, my lord.
चले 1 to 7 का.
Yes, my lord. 1 to 7.
The learned counsel for the respondents request for a copy of the mediation report, which has been sent to the registry. Stop. The secretary DLSA cum coordinator shall provide a copy. Coordinator mediation center Korapur Jaipur shall provide a copy to the learned counsel for the Mr. Murthy for the respondents. Registry shall आपन को copy नेबे. One copy will do.
Yes, will do, man. Will do, man.
Okay. Registry shall do the needful. It is submitted by Mr. Satpathy, learned counsel for the appellant that the mediation has failed. Stop. Still, this court is hopeful that the nature of the appeal, the claim of the appellants and the respondents requires the parties to hopefully would agree for a settlement. Stop. The matter shall be listed for orders in the week commencing 29/6/2024.
Yes, my lord.
Dekhundu, still they keep your efforts up.
Yes, my lord.
Counsel for the parties are requested to keep their efforts on to achieve a mediated settlement.
Then the mediation clause could be changed.
सेटा छाड़ନ୍ତୁ सेटा तो से पारिबेनी डिफिकल्ट माने एक्चुअली मेडिएटर नो पई हमको बुझिया कष्ट आपण मान जदी चेष्टा करिवे कोर्ट किछि करि पारे देखियो यस नेक्स्ट इंट्री ऑर्डर आज पास्ट अर्लियर डेट कहि परिबे इंट्री ऑर्डर डेटेड से shall continue till the next date of hearing. Entry order अच्छी.
Entry order fast.
23/8/2024.
Item 5,
Yes, please.
May I please, my lords? I filed this application.
Your name, sir?
I am on behalf of my senior, Mr. G.K. Acharya, for the petitioner. So,
No, I understand, but you can't represent a senior. So you have to give your name.
my name is P. Jati, sir. P. Jati.
P. Jati.
Right.
Mr. P. Jati for the petitioner.
Yes.
Yes, yes.
Asif, I have filed this application challenging the order dated 11/3/2025, where the Honorable Family Court passed an maintenance of ₹6,000 per month on behalf of my minor daughter, aged about 6 years old. Going to the
Kindly read the order dated 3/5/2025.
11/3/2020.
तीन पांच है. Say paperless use देखो तो. Use the paperless. That is meant for you only.
Yes. It is the order in the last occasion. It is the order of the last occasion. 3/5.
It has a date, sir. 3/5.
Yeah, 3/5. I am challenging.
Disoriented.
Yes, yes, sir.
Read that order.
The matter is taken up for a hybrid arrangement. This present revision is directed against the impugned judgment dated 11/3/2025, passed by the learned judge, Family Court, Hon'Ble, in criminal proceeding number 66/2023, directing the petitioner father to pay a sum of 6,000 per month to OP daughter with effect from 18/12/2023 towards her maintenance in an application under section 125 of the CRPC. Mrs. Arpita Mahapatra, Learned's counsel for the petitioner, after being unsuccessful to convince this court to issue notice against the OP6 for an adjournment of the matter. 3rd July.
Yes. So this is the second round, change of counsel. Instead of Ms. Mahapatra, you are arguing again.
We are from the same chamber.
Chamber does not
Yes.
make distinction between lawyers is not obliterated by joining the same time. It was argued once. The court was not convinced.
Yes, boss.
So you are re-arguing the matter.
I am
So that you should avoid. That you should avoid. Yes.
So, let's say going to the brief facts of the case, the marriage.
Facts. This is a revision.
Yes,
Have you read any? What is the principle of revision? Any decision on revision?
It is the revision for the maintenance, actually.
Yes. What is the case law has evolved? Case law has evolved. Revision is a very old concept, so it has evolved.
Yes, also.
So, have you checked any case law on this?
The Rajneesh versus Neha case law has been cited in this.
With revision. There are other decisions, older decisions. One being Samima Faruqi and latter decisions also.
Lots of. I haven't gone any.
You have to show the court seeking revision.
So
there are 4 or 5 grounds.
Awesome.
Samima Faruqi, Honorable Justice Deepak Misra has summarized that.
Awesome.
Very succinctly, para 20. So scope of revision, you check, then you make your argument. You can't argue from the facts. You have to tell that this was the pleading, this was the evidence, and the court's finding is this. That you may seek revision, no problem.
Okay.
But please apply those parameters so that it becomes legally nuanced. Because whatever was told to you by your client gets filtered at the level of the trial court.
Yes.
Because he himself adduced evidence.
Yes.
He filed his pleadings.
Yes.
He was cross-examined.
Yes, also.
He presented certain documents which
Yes.
are marked as exhibits.
Yes, yes.
So when your client, the petitioner here, comes to you, he has to stick to that.
Awesome.
It is not that by approaching you as to seek revision, he has a second innings to play.
Right. Awesome.
That fast when he was out or he was in, that will stick to him till Supreme Court.
Yes, sir.
So you approach in that method. There is a purpose in telling you. I want to encourage, not discourage.
Yes, yes.
Your approach should be whatever may be the result of the case.
Yes, yes.
Prepare that way and examine.
I'm actually prepared for the facts and the arguments because also I'm not prepared for the.
The problem is that if you prepare facts, you miss the case how it was appraised by the court,
Yes, Lord.
how it was presented by the person before the court. You go through the pleadings,
Yes, Lord.
whatever he's telling you,
No, sir.
because most of the cases you find yesterday only, in fact,
Yes,
it is so casually drafted.
Mhm.
Cause of action has been stated at 4 places differently. In the case of 13-1 application, 13-1, the husband's application against wife.
No, sir.
And maybe counsel much experienced, but he is very young.
Yes.
When he showed that, when I asked him that he please show, he fairly considered that it has been stated at 4 places, 4 times.
Also.
And his objection, Order 7, Rule 11, for rejection of plaint,
Also.
is again the same problem. This could be due to lack of concentration, too much utilization of AI, or maybe copy paste kala belaku se fact adhere misi machi sobu gala mane proper editing hela.
Also.
So this is an example where you have to check the pleadings first, the evidence, and what version he is telling you that should match with that. Then at least the person who is seeking revision, he knows where he stands.
Also.
That is the best part of it.
Yes, Lord.
Because he expects everything. He can completely overturn the judgment. But he had that opportunity. He had the opportunity before the trial court.
Yes, Lord.
So you take your time and prepare and then you submit.
One more occasion may be given.
Yes, please. After
My lord, I am there. My associate is there. If your lordship permits, I can just say something because already the matter has been adjourned once. So only I have 2 points to submit, my lord. If your lordship permits me. Here, what has happened actually, the drivers have.
Mr. Acharya,
I have no problem to that. That is why
and Mr. Jati, they are so promising, you give him a chance.
No, that is why I have sent
You always don't get a chance. They will be always overshadowed by your, stature and presence.
No, that is why I just gave them.
Other day you argue also.
No, only
I mark because your this VC came little bit late. Could be some technical issue, so I marked that.
Right. So actually, my only
difficulty mark that you are present.
Right. My only difficulty is actually they've started with the execution proceeding, my lord, and they are going fast with that execution. And the stage has come. We have
advise your client that it can come next week. You advise that let him deposit the amount.
I'll do that.
We can. So next week,
please, and I would be grateful.
Appearance Mr. Acharya, Mr. GK Acharya, Senior Counsel, along with Mr. P. Jatti and Ms. A. Mahapatra for the petitioner. The learned senior advocate submits that for the petitioner submits that the matter may be adjourned next week to enable him to obtain instruction. Stop. Accordingly, the matter the order dated 3/5/2025. The learned counsel is apprised of the learned senior counsel is apprised of the earlier order by the coordinate bench dated 3/5/2025. As adjournment 6 adjournment proclamation. The matter shall be listed for fresh admission in the week commencing 18/5.
Grateful.
Yes.
Oblige.
Yes, please.
Item 8.
Mr. Niranjan Singh for the petitioner.
Directly to file an affidavit whether you are paying the monthly maintenance.
Sir, please kindly refer to the order. It is submitted by the learned counsel for the petitioner that as per his instruction, the petitioner goes on paying the amount directed earlier. Vijayara and Hajare, since the said aspect has not been mentioned in the application supported by affidavit, the petitioner shall file affidavit giving details. Then and the affidavit.
There is affidavit. I am paying regularly. I am affidavit.
ଆପଣ ତ ଏପଟେ ଇତିହାସ ଲେଖିଛନ୍ତି ଆପଣ affidavit ଗୋଟେ ଲାଇନ ହବା କଥା ଆପଣ ଦେଇଛନ୍ତି 9 ପୃଷ୍ଠା 3 କୋଉଠି ଲେଖିଲେ ଯେ ଦେଉଛନ୍ତି କୋଉଠି ମୋଡ ଆଣ୍ଡ ମେଥଡ ଅଫ ପେମେଣ୍ଟ ସେତିକି ଲେଖିବା
regular I am paying.
ମୁଁ ଫୁଲ ନାଇଁ ସେମିତି ହବ ବାଲ୍ଡ ଷ୍ଟେଟମେଣ୍ଟ ଦିଅନ୍ତୁନି leave this habit. Ask your they will not honor you, sir. If you leave your client like this, ଦଉଛି କହିଲେ ଆପଣ ପଚାରିବେ ଆଜ୍ଞା କେବେ କେବେ ଡିଟେଲ୍ସ ଦେବେ. The learned counsel for the petitioner refers to the appearance dakili. Learned counsel for the petitioner refers to the affidavit dated 4/5/2026 filed on 4/5/2026 purportedly in compliance of the order dated 1/5/2024 paragraph 2. Paragraph 2 of the order, the said order is reproduced herein. Stop. Perusal of the affidavit indicates that the petitioner has only made a bald statement that he is paying. Stop. The petitioner shall file a very brief affidavit indicating amount paid, date of payment, mode of payment in tabular form. ଆପଣ ଯେତେ ବଢେଇବେ ସେ କହିବେ ମୁଁ ବହୁତ ଭଲ ଲୋକ, ମୁଁ ଯାହା କହେ ଠିକ କହେ, ମୁଁ ସତ କହେ, ସେଇଟା ସାର୍ ଭଲ କଥା। ଆମର ସାର୍ factually you should be sound that much. ନହେଲେ ସେ ଆପଣଙ୍କୁ ମାନିବେନି, ସେ ଆପଣଙ୍କୁ ସବୁଦିନ ଗୋଟେ ଗୋଟେ କଥା କହିବେ। ହଁ yes, କେବେ ଆସିବ? After vacation.
नेक्स्ट वीक आसे मैं दे देबे का
ସେ details ତାଙ୍କୁ details ଦେବେ।
हम करू आज कोई
The matter shall be listed for fresh admission in the week commencing 18/5. Yes, please.
आइटम 9
SLP ଟା ସେଟା ଦେଖିଦେଲେ। ଅର୍ଡର ବାହାରିଗଲା। ମାନେ ଡିଟେଲ ଅର୍ଡର ନା ନାଇଁ? ୱାନ୍ ପେଜରେ କଣ ଅଛି? ରିଜନିଂ କଣ? ପ୍ରିଣ୍ଟ କରି ଆଣିପାରିବେ? ଦେଖିବା ଠିକ ଅଛି। Yes, please.
May I please, Your Lordship?
Mr. Lingaraj Solanki for the petitioner. Yes, please.
My Lord,
Opposite party blank. You are seeking enhancement of maintenance.
My Lord.
Ground, sir?
Grounds it has been.
High international ପିଲା ପଢିବେ ନା କଣ?
My Lord.
ଜଣେ କହିଲେ ଯେ ପିଲା ହାଇ ଇଣ୍ଟରନ୍ୟାସନାଲ ପଢିବ ଟଙ୍କା ଦିଅନ୍ତୁ, ସେମିତି କଣ ହେଇପାରିବ? ଆପଣ ସପିଂ ଖାଲି କରିବେ ସପିଂ ମଲରେ, and that too in Esplanade. ଆପଣ Esplanade ଯିବେ, you can go. ସମସ୍ତେ କଣ ଯିବେ? So these are the points you have to talk to your client. Be practical, be optimistic. Stretching the maintenance to that extent.
My Lord.
International school ରେ ପଢିବେ। ସେମିତି କଣ ଆପଣ ଯାହାର ଅସୁବିଧା ଅଛି ସମସ୍ତେ ଇଣ୍ଟରନ୍ୟାସନାଲ ସ୍କୁଲରେ ପଢୁଛନ୍ତି କି? ପଢୁନାହାନ୍ତି। कौन ग्राउंड कौन कौन तो सर
In this case the net salary has been reflected of the opposite party is 73,049, my lord. However, no salary slip has been produced. The salary slip which has been
what he does, what is his designation? Because
accepted
yesterday one executive engineer produced 60,000. The court accepted.
again.
The Daftari in the court where the court is sitting, his scale is 67,000.
Again. Agriculture
The
officer.
supervisor, that effort you should have made actually. Because for a government servant, it is easier to get. You should have taken care of that.
My lord, I have.
Anyway, you take notice.
Yes.
But please don't be. I mean, don't stretch it to that extent that खर्च या हबो एमती हवा दरकार. At least. At London Council for the petitioner wife in the marriage is before this court seeking revision of the judgment dated 9/1/2026.
11/2, my lord.
Just one. Move out of the full day. No. So I have opened another page.
Page number 130, my lord.
Item 15, no. Okay. Under the counsel for the petitioner on the For this court seeking revision of the judgment dated 11/2/2026 passed by the Learned Judge Family Court, Khurda, in criminal petition number 257 of 2023. Stop. The petition was filed by the wife in the marriage under section 125 of the CRPC, 1973, into bracket, since repealed and substituted by pragmatic provision.
140.
Content in the BNSS 144 and 44 BNSS 2023 bracket closed, seeking monthly maintenance. At the rate of
40,000.
40,000 per month. And 50,000 towards litigation expenses. It is submitted that the expense stop. So the petition was favored. However, directing payment of monthly maintenance at the rate of 10,000. 9,000. From the date of filing of the proceeding, that is on 3/8/2023. It is submitted that the amount directed to be paid as monthly maintenance is less compared to the income of the opposite party as well as the other relevant factors. Of the opposite party, comma, and the other relevant factors for determining the monthly maintenance have not been taken note of by the Learned Court. The issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. Date be fixed to date कोटा दो चलिए अबे सब बारीक रिटर्नेबल डेट फिक्स टू को दिन देबे 6-7 लिस्टिंग 6-7 दो चंदी रिटर्नेबल डेट भी फिक्स टू 29/6/20 30/6 कर दे 30/6/2026 the matter shall be listed for orders in the week commencing 6/7/2026. This for para, it is for the directed that the petitioner shall continue to receive the amount directed by the Learned Judge Family Court without prejudice to her rights and contentions in the present application.
One interim application.
आइए to lie over. आइए तो final prayer अपन करते हैं. आइए इतने लिखी हुए 126/2026. आइए सर lie over. ठीक है.
Item 10.
Deeply.
Yes, please. Password कर दो मैम.
11.
PC Das for the. Mr.
I am S. Das.
Mr. S. Das for the petitioner.
Yes, ma'am.
Yes, please.
Here the petitioner challenged the order dated 14/3/2016 or 2019.
Yes, please.
Where the Learned Court has directed the petitioner to pay 10,000 rupees to the opposite party as monthly maintenance, your lordship.
Yes.
And the court below has issued frame for issues, your lordship.
No. Go to first you take your ground, sir. Ground of revision, seeking revision.
Ground, my lord.
Who grounded? Just like I was discussing with very young person.
In this case, my lord, the Learned Court has not believed the version of the opposite party, and in 125 CRPC, it is the duty of the wife to prove the income and assets of the husband, your lordship.
Co-provision, duty of the wife to prove income.
In 125 CRPC, duty notice, it has to be proved by the wife.
What is it? A case law, section, provision. It can't be a matter of speech or my perception. I am so impressed.
No, in paragraph 3.
Please, Mr. Das, kindly listen. I am so impressed with your. Can I pass that order?
No.
That's the problem, sir. I am so impressed. If I record that, I am really impressed by Mr. Das's version. If the onus lies on the wife to prove the income and everything of the husband, that there the law is very well settled.
No.
She has only to prove that she is neglected. Because have you noted the provision? 125 is very clear on that.
He has been neglected. He has to prove he has been neglected, my lord. In this case,
That is enough. Now, regarding what was your case before the trial court and how the court evaluated, and if you say that since the trial court has not believed the opposite party, that the revision should be made, that cannot be, because court has to accept one version and reject one version.
Yes.
So you have to find out how the court, on which ground you are seeking revision. Because revision, Mr. Das, revision is so limited that High Court cannot interfere, even if High Court thinks that there can be alternative interpretation. That is what the Apex Court has held.
I may be permitted to show issue number 3, your lordship, at
Issue
page
ଟା ଦେଖିଛନ୍ତି ଆଗ pleadings ଯିବେ ଆପଣଙ୍କ version କ'ଣ ଥିଲା, how you registered,
I have
then show the what was your evidence. That will form the basis of you challenging the order. ଆପଣଙ୍କ pleadings को ଯାଆନ୍ତୁ.
in pleadings, my lord, I have categorically
actually ଆପଣଙ୍କ brief ରେ ନାହିଁ.
brief ଅଛି, lordship.
So brief ରେ ନ ରଖିଲେ ଆପଣଙ୍କ ପାଇଁ ଅସୁବିଧା କ'ଣ ନା ମୁଁ ତ ଆପଣଙ୍କ RPFM କେତେ କି 348 ଠିକ ଖୋଲିଛି ତ.
Yes, my lord, I have mentioned in para 5, lordship.
Para 5 ନୁହଁ, WS
WS ରେ ଅଛି, lordship.
WS ନାହିଁ, ଆପଣ ଦେଖୁନାହାନ୍ତି. ଆପଣଙ୍କ ଆସୋସିଏଟ କୁ କହୁନାହାନ୍ତି ସେ ଖୋଲିଦେବେ. ଆପଣ ଏଇଟା କୋର୍ଟ ବ୍ରିଫ ଟା ଖୋଲିଦିଅନ୍ତୁ.
Court brief.
ନାଇଁ ସେଇଟା ଆପଣ ପଢିଲେ ହବନି, ଆପଣ କୋର୍ଟରେ ଫାଇଲ କରିବେ ନା.
Court brief.
କୋର୍ଟ ବ୍ରିଫରେ ନାହିଁ ସେଇଟା.
But I have filed my written version in the court below, lordship.
whatever ଆପଣ ସେଇଟା ଦେଖିବେ ନା ସେଠି. ମତେ ଆପଣ ଏଠି ପ୍ଲେସ୍ କରିବେ ଯେ that was your contention and how it was dealt with.
Yes, lordship. CRP 215.
ଯୋଉ 19 ଦିନ ଅର୍ଡରଟା ବି ଏଠି ରଖିଲେ ଏଠି ରଖିଦେଉଛି.
CRP 300.
So ଦାସ ଆପଣ ସେଟାକୁ ଫାଇଲ କରନ୍ତୁ. ଆପଣ ଯଦି ଏକ୍ସଟେମ୍ପୋର ସବମିଶନ କରିବେ ହବନି. You have to go through place the pleadings, what was your ground of registering the claim. ଆପଣ ସେଟା ରେକର୍ଡରେ ନାହିଁ.
Then I may be permitted to file the written version of the
Whenever you file, but the difficulty is that I cannot assess without those things. ଆପଣ ଷ୍ଟେଟ୍ ହାଇୱେ ଜଜମେଣ୍ଟ କୁ ଗଲେ ମୁଁ କେମିତି ଜାଣିବି?
ଜଜମେଣ୍ଟ ନାହିଁ ଭାଇ ସାର୍, ଯଦି
ଆପଣ ଯାହା ରିଲାଏ କରୁଛନ୍ତି ଆପଣ ଫାଇଲ କରନ୍ତୁ କୋର୍ଟରେ. Bring it on record.
ଆଜ୍ଞା.
Because that forms the basis. ସେଟା ଦେଲେ କି ସେପଟେ ଆପଣ ଫେର ଚାଲିଲେ କାହିଁକି? ତାକୁ କୁହନ୍ତୁ ସେ ଦେଇଦେବେ, ତାହେଲେ ବଢେଇ ଦେବେ ସେଟା. ଆପଣଙ୍କର ପ୍ରିନ୍ସିପାଲ ଗ୍ରାଉଣ୍ଡ ଅଫ ରେଜିଷ୍ଟାନ୍ସ କ'ଣ ଥିଲା?
Sir,
How did you register the payment of maintenance to wife under 125? How did your client, what was his version?
He, at the time of proceeding, your lordship, he has lost his job, my lord, and he is the dependent upon his parents, your lordship, and he appeared in various interview and not succeeded in that interview, your lordship.
So have you examined the case law on this? This has been handled by Supreme Court elaborately so many years. Recently, no. When a married person says that I have lost my job, appearing in interview, but every time I fail, I depend on my parents, then what is the answer of the Supreme Court?
The husband has to maintain his wife.
No. Husband has to maintain his wife.
But the quantum of, I am challenging the quantum of the maintenance, your lordship.
What is the quantum that has been awarded?
10,000, lordship.
10,000. So how much you will give?
Then I have to take.
Have you checked? The Supreme Court has said that if the daily wages are, you have to did you adduce any evidence before the court stating that you are incapacitated for genuine reasons to not to pay any work and may pay anything? By simply saying that I'm dependent on my parents is not appealing to the courts. Courts say that an able-bodied individual has to work to fend for himself and his family.
Yes, ma'am.
So did you say, tell me the court or adduce evidence that for bona fide reasons you are unable to earn anything? দেখুন তো
Next day
you
to
have your time.
I will file everything, my lord.
Had the learned counsel, the petitioner, the husband in the marriage is petitioner before this court seeking revision of judgment and order dated 14/3/2019. Even you will find Mr. Das.
Yes, my lord.
Even the apex court has followed some decisions of Odisha High Court also. It is not that we are not rich in jurisprudence, but you have to make that effort. कौन लिख ले? Yeah, challenging the seeking revision of the judgment dated 14/3/2019 passed by the learned judge family court Bhubaneswar in criminal proceeding number 215 of 2016 215/2016. The matter was presented before this court on 12/12/2022. No. And you are not paying till date?
No, my lord, I have no instruction in that matter. Whether the petitioner has paid any amount to the opposite party.
Presented before this court on so and so date. Since it was defective by order dated 13/3/2026, defects were directed to be removed. The matter was heard at some length on 9/4/2026. The facts as well as the legal issues were noted. Stuff. Referring to para 3 of the order dated 9/4/2026, is submitted by the learned counsel for the petitioner. The matter may be adjourned to enable him to go through the pleadings before the learned trial court, pleadings and evidence before the learned trial court. Para. This is further submitted by the learned counsel for the petitioner that the petitioner has lost his job. Wherever he appears for interview, he is unsuccessful. He is dependent on his parents, for which he seeks reduction of the monthly maintenance that has been awarded at the rate of ₹10,000. Stop. The learned petitioner is apprised of the judgments rendered by the Honorable Apex Court in Samima Faruqi versus Sahid Khan, citation they given, and Rajneesh versus Neha, wherein it has been held that the plea of incapacity to earn has to be pleaded and proved before the trial court, before the court in the proceeding under section 125 of CRPC. Stuff. As prayed for, the matter shall be listed for orders in the week commencing after vacation on 3/6/2026 to grant further opportunity to the petition. Yes, next please.
Item 12.
So Prem Kumar Mahanti, additional standing counsel for the appellates. Mr. Paradis, you have filed objection to the IA.
Yes, they have filed objection. There is only 122 days of delay.
So you want,
as per Honorable Apex Court judgment in Deputy Commissioner versus SP Global, it has been condoned.
No, does this issue the same issue as
Yes,
in
it
SP Global?
There the appellants were the land oustees.
And up to
Here the appellant is the commandants.
But if you say the legal principle, at
same
least it has to be even-handedly applied. So, upon a cost, kete debe? They are land losers. Kete debe?
As your lord
Never.
decides.
No, no, upon instruction नहीं होती. I
I'll
can't
take
compel you. Mr. Paradis, kete cost na nahi condone kar debi.
The matter we condone, my lords, order merits because, my lords, I have
500 दियो तो. ହେଲା? Parents कौन लिख ले? हाँ. For the appellant, Mr. Mohammed Farhad is for the respondent. IA 48 of 2022. IA has been filed seeking condonation of reported delay of 123 days in filing the appeal. The appeal has been filed challenging the judgment dated 5/11/2021 passed by the learned presiding officer, land acquisition, land acquisition, rehabilitation and resettlement authority into bracket Northern Division, bracket closed, Sambalpur, in land acquisition case number 45 of 2021. The said case was pursuant to a reference under section 64 of the rights, RFC Act 2013. Made by the land acquisition zone officer, Khurda Road, Balangir, new broadgauge red link project, Balangir, arising out of the protest petition filed by the present respondent, who was the petitioner, dated 27/11/2018. Stop. The learned additional standing counsels, referring to the grounds stated in the application seeking condonation of delay, submits that the statements made are sufficient to condone the delay as being reasonable. They being reasonable, we relies on the decision of the Honorable Apex Court in so and so versus
SP Global Mill.
SP Global.
Mill Limited.
SP Global. To submit that the said principle would apply for condonation of delay in the present application. But Mr. Farhad is that 60 plus 60 can be condoned. That's a 60 plus 60 or 90 plus 90 days. 90 plus. So that the paragraph quote the Honorable Apex Court in SP Global has observed thus. Last paragraph. The learned counsel for the respondent submits that the respondent is a land user. He has been put to the further litigation for receiving the compensation, which was compensation for the acquisition, which was initiated. In the year 2018. Stop. Para. Having heard the learned additional standing counsel for the appellant and the Mr. Farhad is for the respondent, is directed that the delay in filing the appeal, the delay of reported delay of 123 days in filing the appeal shall be condoned subject to payment of cost of ₹500. How many respondents, sir?
Only one.
One. To the respondent. The cost shall be paid within, Mr. Mahanti?
Within 2 weeks.
Within 15 marking days. Because he can't pay from his pocket, so it's considered. The matter shall be listed for orders in the week commencing 29/6/2026. Upon the file you talk to them.
Yes.
That some token amount you pay to the land user.
No.
500 crore कितना रहेगा fresh? 40. Your matter. Okay. Ms. Gindi Misra for the petitioner. Yes.
May it please, Your Lordship. Your Lordship, we have filed a transfer petition.
Yes.
For transfer of MAT case number 9 of 2026 that has been filed by the husband for restitution of conjugal rights, Your Lordship.
So the lady doesn't want for restitution, or she wants restitution?
We eventually they go, as of now she doesn't want restitution, but she wants to contest the case in family court Baripata, Your Lordship. Any court within.
She doesn't wish to continue the matrimony.
Yes, Your Lordship.
She has a counter claim, or maybe she.
Yes, Your Lordship. She has subsequently.
Ms. Binny Misra for the petitioner, opposite party blank. The wife in the marriage is before this court seeking transfer of CP number 80. MAT case number. MAT case number 09 of 2026.
Yes, we did.
Pending before the Learned Civil Judge, Senior Division, Uddala. To be transferred to the Learned Judge Family Court, Baripada at Mayurvanj. The MAT case has been initiated under Section 9 of the Hindu Marriage Act, 1955, by the husband in the marriage seeking restitution of conjugal rights. Stop. It is submitted by the Learned Counsel for the petitioner that after the marriage has gone into rough weather, the petitioner wife stays with her parents at Baripada.
Yes, Your Lordship.
Baripada. She finds it difficult to attend the matter at Uddala. Uddala and Baripada are not far off places.
50 kilometers
Yes,
difference.
so that cannot be far. Issue notice along with this order. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 7 days or 5 days.
5 days.
Within 5 working days. Returnable date be fixed to KBR upon date posting. Return dates be fixed to TDC. The matter shall be listed for orders in the week commencing 6/7/2026. Stop. IA 148 of 2026. Heard Learned Counsel for the petitioner, she reiterates her submissions as noted above. Stop. Issue notice as above. Accept one set of process fee as well as postal requisites. The returnable date and the next date of listing shall be as directed above. In the interim, it is directed. The MAT case number 9 of 20222 pending in the Court of Civil Judge Senior Division. The Uddala Baripada Uddala shall be adjourned to a date beyond. Beyond 13/7/2026 to a date as would be convenient to the Learned Court in season of the matter. The opening statement line, which is submitted by Ms. Misra, Learned Counsel for the petitioner, that inadvertent typographical error has crept into the. Upon Sobuti said, Baripada Uddala change कर दी चंदना कौन?
Your Lordship, correct.
और आइए देखिए आइए
Your Lordship, only in the cost title.
आइए रे क्या बोलो भूलिए
No, खाली गोटे बोलছি. Say cost title of the IRA.
Say IRA dal lekhuntu, it is submitted by the Learned Counsel for the petitioner that she may be permitted to correct the inadvertent typographical error that has crept into the first title of the IA. Stop. Leave granted, the Learned Counsel shall carry out the necessary correction in the cost title of IA 148 of 2026, which shall bear her initials to be countersigned by the court master. They filed a the corrected cost title shall be also scanned and updated. Correction Yes, next.
I am on VC Milan.
Yes, Mr. Murthy.
My lords, if at all, kindly be passed over.
Pass over.
My lords.
The request is
what I'm told is actually this will go to for mediation.
No. It's for
case has been filed for early hearing of the case.
There is a
yes, right. Yes, I did
for
know.
that purpose.
Early hearing, sir, the computer early hearing of aguru sina choice thila court ro.
Again.
The computer system re se tankar se computer korchundi.
Oh, sir. In
fact, one day it was argued almost that mandava should be issued against the computer. So it will come upon it after notice. Mr.
My lord, in this case, I am appearing for opposite party number 4 to 6.
Yes.
The Ministry of Consumer Affairs, Food and Public Distribution.
Yes.
We have filed our counter in 3 cases, my lord.
Sir, Mr. Mishra, let us go one by one.
Yes.
Authorized, it is difficult for them to take
As you
because they find it very difficult. Bhulval issue.
again.
Mr. T. Narayan Murthy for the
Petitioner.
with Miss S.L. Sinha. Sinha padele. S.L. Sinha for the petitioner. Mr. Prem Kumar Mahanti, Additional Standing Counsel for the OP1. Mr. Bigyan Sharma, Senior Counsel, along with, sir, your name?
Sanket Palai.
Sanket.
Sanket Palai.
Mr. Sanket Palai for
OP number 2 and 3.
2 and 3. Apna, sir,
4,
CI
5, 5 and
Yes, sir,
My lords, I
this
am
law.
appearing on behalf of Mr. Naik for FCI.
Your
OP 4 and 5.
Acha. Mr.
I am
Mr. Debashish Naik.
number 6.
Mr. Apna name, sir?
Vishal Mahapatra.
Vishal Mahapatra.
Again.
So Vishal Mahapatra along with Mr. Devashish Naik along with Mr. Vishal Mahapatra on behalf of opposite parties 4 and 5. Mr. BP Misra, Senior Panel Counsel for OP6.
Yes.
7 of Anantaram Foods.
We did change the position.
6 none. Notice जाइथिला 6 को notice जाइछ ना ना हेनी
7.
No, contesting opposite party is Food Corporation of India. It is the direction of the Food Corporation and they are supposed to be complied with.
When notices were issued, 2, 5 and 7 notice each. 7 key.
They are the supplier of FRK kernels.
Notice is there. Notice each. Tell me, OP7 none कर दे. OP7 none. IA 2606 of 2026. The IA has been keyed a file coaching.
My lords,
So
my lord-
you have filed?
Yes,
Apna
ma'am.
file coaching.
Yes, ma'am.
The IA has been filed by the opposite party number 4 and 5. For early hearing of the matter, stop. In view of the computerized listing system, the matter has its own priority and shall be taken up on the earliest possible date that would be available.
My lords, this
The parties are requested to complete the pleadings. Pleading complete each.
Almost all.
If not, the parties are requested to complete the pleadings and exchange the same. If not already done, stuff by the next date. The matter shall be listed for admission in the week commencing. Mr. Mishra, इतने अपन कौन कोपले हो?
ଏଥିରେ ଆମେ କହୁଥିଲୁ ଆମେ କାଉଣ୍ଟର ଦେଇ ଦେଇଛୁ ଅଲରେଡି କପିଟା ରିସିଭ କରିନାହାନ୍ତି ମିଷ୍ଟର ମୂର୍ତ୍ତି ତାଙ୍କର କିଏ ନାହାନ୍ତି।
ସେ ତାଙ୍କର ଆସୋସିଏଟ ଥିଲେ ପଡେ ଗଲେ
ମୁଁ କଲେକ୍ଟ କରେଇନେବି ସାର୍ ଯଦି if it is available in the court's record then I will get it collected below.
No, it is not available.
So that order I have passed that please complete the pleadings.
Yes, ma'am.
At least we have to honor the request of the OP4 and 5 that let us complete the pleadings and the matter be ready, exchange it.
Yes.
Complete the pleadings and exchange the same. Yes. By what time, sir? Pleading केबे complete होगा जीजा फाइल करना आंटी केबे अपन डेट कर ले 20 साथ है the pleadings be completed जो लेके डेट कर दियो तू नहीं नेक्स्ट डेट करो तू completed by कर दियो तू एक साथ sufficient time दिया एक साथ second matter रे Mr. T.N. Murthy, Lord Counsel, being present at the virtual court, High Court of Orissa, Koraput at Jaipur, addresses are please. Second matter रे same appearance.
My lords.
Yes.
Say आइए same आइए.
My lords.
ଆପଣଙ୍କର ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଆଉଟ୍ ଆପିୟର କରୁଛନ୍ତି? ଯଦି ଏନି ଡିଫରେଣ୍ଟ କାଉନସିଲ ଆପିୟର କରୁଛନ୍ତି ପ୍ଲିଜ ଜଷ୍ଟ गिव इट इन अ पिस ऑफ पेपर ସବୁଥିରେ ଆପଣ କରୁଛନ୍ତି
almost but the last one
you are having the lion's share of the cake today Usually all of you appear in different matters.
A case become rotten virtually because foods are supposed to be replaced. So it's pending.
Sir, for
It has
central
become
government,
rotten.
never rotten, sir. Central government. For state council, it is rotten because only one brief. For them, it is every individual brief. State so and that too per day. For brief smoking, for appearance bonus, including pleadings and everything. Counter jaha karibe, file karibe, सब fixed कोटे working day रे खाली. Yes. So बड़ा same data रहता.
Last one रे.
हाँ. Last one रे.
WPC 36869/23. It is they have not given me a copy of the writ petition, so that.
कोतरे कहार copy पाइनांती कोंतु सेते audio
सबू पाइछंती.
Mahapatra, you have received copy in all matters. Mr. Mahanti,
yes.
Paichani copy. Mr. Sharma, you have received copy. So only one matter. Then 36869 36869. It is submitted by the learned CGC that he has not received copy.
Senior panel.
I'm sorry. The senior panel counsel submits that he has not received copy. The petitioner shall serve extra copy of the writ application within 3 working days.
Maybe 1 week.
Within 7 working days.
Yes.
But same pleadings to be completed by 1/7.
Yes, my lord.
All matter. Okay. Would I had disposed? Yes. Mr. Das.
Item 14.
But I have changed the order dated.
Madam, I am opposite party in this case, my lord. And copy of the IA not sought from me, my lord.
Madam, challenge the order dated 3/6/2024, passed in CRP number 142/2019 by the Judge Family Court Hon'Ble before this honorable court in RPL.
Sir, just look at the order dated 22/11/2024.
Yes, madam. I'm coming with that. In paragraph 3, madam.
We have to be quick.
In the course of hearing, Mr. Ashwini Kumar Das ran counsel for the petitioner by inviting attention to the court to the judgment passed by the Land Judge Family Court Hon'Ble in CP case number 64 of 2017 submits that the marriage between the petitioner and the OP already been dissolved, but the OP wife after dissolution of her marriage has filed this proceeding under 125 CRPC for grant of maintenance, but the fact remains that the OP wife has voluntarily deserted her own husband without any sufficient reason, and thereby the decree of divorce has been granted by the Judge Family
Yes, sir. Principal ground in 125 re.
Yes, madam.
Divorced wife.
Divorces are the wife left the matrimonial home, saying that he will not stay with the husband.
So सेटा what आपनकर pleading देखांतु. Written statement देखांतु.
Sir, देखुची. The Judge Family Court is
you sit down, sir. Pasul.
The Judge Family Court.
Mr. Ashwini Kumar Das for the petitioner, Mr. Rajendra Kumar Pradhan for the opposite party.
Madam, I have filed in my so-called there.
देखान.
एक कोर्ट जीवन.
नहीं सेटा मते कोर्ट रे देखेबे ना. तेरा record रे कोर्ट देखेबे.
Order ଅଛି sir.
Order नहीं.
Second account.
Order, I cannot rely on the version of the trial court. You have to show what you have filed there. What was your stand there?
I have filed the
anyway, let us not spend time. You want stay of the further execution.
What is
deposit kete karibe? Kete tanga deposit karibe? Kete tanga area karibe?
Madam, I have denying the
very good.
125.
Very good. You will be refunded. Apan jo deny karuchanti, Mr. Das, you will be refunded the money. देखा जो आपण recovery suit file करिवे, but you can't bargain a decree. Upon you can't deny a decree. Must understand. Because I like you, I will pass that order.
Madam, I rely on your lordship can see I rely on decision of the Hon'Ble Kerala High Court.
Supreme Court na Kerala High Court no. Supreme Court rely karo.
Supreme Court.
Supreme Court.
Yes, Supreme Court. Madam, Supreme Court also directly not refuse the 125/4.
Supreme Court re apanakara co decision rely karo na kuantu. I have a problem of not unable to forget. So, seta apan koibe so that I will realize that what you are saying has some substance. Let us not spend time like this. ଆପଣ ପଇସା ଦେବେନି ଏକ୍ଜିକ୍ୟୁସନ ହବନି I will help no court will not help answer is plain and simple
ସେଇ ସୁପ୍ରିମ କୋର୍ଟ
କୋଉ ଡିସିଜନ ରେ କହିଲେ ଯେ 125 ରେ ହାଇକୋର୍ଟ ଷ୍ଟେ କରିଦେବେ ପଇସା ଦେବା ଦରକାର ନାହିଁ
125
execution रे rather execution ଶୁଣନ୍ତୁ Mr. Das what has happened now the Supreme Court has become very stringent in execution court is asking us why you are keeping the asking us we are asking
I am don't like that man.
Yes so you have to secure the decree challenge it
your lordship can see the
ଆପଣ secure କରିବେ ନା ନାହିଁ sir
କୋଉଠି sir
I have record ଆପଣ decree secure deposit କରିବେ ସେଠି ପଇସା କେତେ ଟଙ୍କା deposit କରିବେ କେତେ ଟଙ୍କା ଏରିଆ କହିବେ
10,000 deposit କରିବେ
ନା 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 it is sir I am not requesting ଏଟା କଣ ବ୍ୟବହାର ନା କଣ 101 sir decree of ବ୍ୟବହାର
17,000
କେତେ ଟଙ୍କା ଏରିଆ କେତେ ଟଙ୍କା ଅଛି
17,000 ପାଇଁ ସେ ପଠେଇଛି
କେତେ ଟଙ୍କା ଅଛି sir ଏରିଆ ନହେଲେ ଏକ୍ଜିକ୍ୟୁସନ କେତେ ଟଙ୍କାର ଫାଇଲ ସେତିକି ହେଲେ କୁହନ୍ତୁ
17,000 ଟଙ୍କା ସେ ପଠେଇଛି ପରେ ଏକ୍ଜିକ୍ୟୁସନ କରି ସାର୍ ଏବେ ଏଇ ରିସେଣ୍ଟଲି ଦେଖନ୍ତୁ ଏଇଟା
ଏକ୍ଜିକ୍ୟୁସନ ସାର୍ କେତେ ଟଙ୍କା ସାର୍ କହିବେ
Actually, I have no instruction.
ଆଚ୍ଛା ଠିକ ଅଛି I'll find out ଏକ୍ଜିକ୍ୟୁସନ ମୁଁ ଫାଇଲ
I obtained the certificate copy sir
ସାର୍ଟିଫାଇଡ କପି ନୁହଁ ସାର୍ ଆପଣ ଏରିଆର କେତେ ସାର୍ଟିଫାଇଡ କପି କହୁଛନ୍ତି
17,000 ଟଙ୍କାର ଏକ୍ଜିକ୍ୟୁସନ ପଠେଇଯିବା କହିଲେ ରାଣୀ ଏଇ ୟା ପାଇଁ ତ ମୁଁ ଫାଇଲ କରିଛି
ସାର୍ ଦେଖିଲି ସାର୍
ୟା ପାଇଁ ମୁଁ ଫାଇଲ କରିଛି
ଏକ୍ଜିକ୍ୟୁସନ ଟା ଟିକେ ଦେଖାନ୍ତୁ ସେ କଥା ଦେଖିସାରନ୍ତୁ ତାପରେ ମୁଁ ଦେଖିବି
ଏ ଦେଖନ୍ତୁ ଏଥିପାଇଁ ତ ମୁଁ 120 ମାନେ ଏବେ ତ ଫାଇଲ କରି ପାରୁଥିଲି ବୁଝିପାରିଲେ
Area maintenance amounting to rupees 4,57,660.
4,57,000 କେତେ ଦେବେ
17,000 ପଠାଇ
No, that is monthly installment. That is monthly
ଆଜ୍ଞା ମୁଁ ଚାକିରି
ସାର୍ ଶୁଣନ୍ତୁ ଆପଣ ଯୋଉଟା ପଢିବେ ସେଟା ସିଏ ପଢିବେନି
ମୁଁ ଚାକିରି କରୁଛି 40,000 ଟଙ୍କା ଦରମା ପାଉଛି ମାଷ୍ଟର
40 ପାଉଛନ୍ତି କି 4 ଟଙ୍କା ପାଉଛନ୍ତି ସାର୍ ଦ୍ୟାଟ୍ ଇଜ ନଟ୍ କନସର୍ନ
ମୁଁ ଇନଷ୍ଟଲମେଣ୍ଟ 17,000
ଇନଷ୍ଟଲମେଣ୍ଟ ନାହିଁ ଆପଣ ଏରିଆ ଇନଷ୍ଟଲମେଣ୍ଟ ରଖିଥିଲେ କି ଯୋଉ ଦେଲେନି ଇନଷ୍ଟଲମେଣ୍ଟ ନ ଦେଇଥିଲେ କି
ସାର୍ 125
ଆପଣ ଦେଇଥିଲେ ସେଟା କହିଥାନ୍ତେ
ତମେ ଭେରି ବିଗିନିଂ ମାର
1,57,000 ରୁ କେତେ ଟଙ୍କା ଦେବେ କୁହନ୍ତୁ ସାର୍ ନହେଲେ
ମୋ କଥା
ସାର୍ ଶୁଣନ୍ତୁ the difference between a henchman and a lawyer is that you are at a higher level
ମୋ କଥା
ସିଏ ଅଲ୍ଟରନେଟିଭ ଆପଣଙ୍କ କଥା ଶୁଣିଲା ପରେ ମୁଁ କହୁଛି ନା ନ ଶୁଣିକି କହୁଛି ମୁଁ ଜାଣିଲି କେମିତି ଆପଣ 4,57,000 ବାକି ଅଛି
ସାର୍ ଦେଖନ୍ତୁ
you stick to law
who made her to write document in before the husband that I will leave the company the husband on my own
ସେଟା ଆପଣଙ୍କର ଦେଖିବେ ପଢିଲେ ହବ with your age and experience you also develop a habit of reading those grounds are untenable
ଏଇଟା ସାର୍ ମୁଁ ମ୍ୟାନୁଫ୍ୟାକ୍ଚର କରିନି ଆପଣ
ଦେଖନ୍ତୁ ସାର୍ ଶୁଣନ୍ତୁ ଆପଣ ଏଠି ଦେଖାନ୍ତୁନି ମୁଁ ଟ୍ରାଏଲ କରୁନି
ମୁଁ ଟ୍ରାଏଲ
ଆପଣ ଯାହା ଟ୍ରାଏଲ କୋର୍ଟରେ ଦେଖେଇଥିଲେ ସେଟା ଦେଖାଯିବ ଟଙ୍କା ଫେରି ପାଇବେ ବା ଫ୍ୟୁଚରରେ ଦେବେନି
ଦେଖନ୍ତୁ ମୁଁ ନିଜେ ଟ୍ରାଏଲ
ସାର୍ ଲେଟ୍ ଅସ୍ ନଟ୍ ୱେଷ୍ଟ ଟାଇମ୍ ସାର୍ ଆପଣ ଯାହା ପ୍ରିଡିଂସ୍ ଥିଲା ସେଟା କୋଉ ଏକ୍ସିବିଟ୍ ମୁଁ ଦେଖିବି ସେଟା କେତେ ନମ୍ବର ଏକ୍ସିବିଟ୍ ଟ୍ରାଏଲ କୋର୍ଟରେ ଯୋଉଟା ଧରିଛନ୍ତି ସେଟା ଏକ୍ସିବିଟ୍ ନମ୍ବର କେତେ ନମ୍ବର
ଏକ୍ସିବିଟ୍
A B C D ଆପଣ ଡିପେଣ୍ଡେଣ୍ଟ A B C D କେତେ ନମ୍ବର ଏକ୍ସିବିଟ୍
ମାର କରୁଛି ଏକ୍ସିବିଟ୍
Exhibit A and B.
Exhibit A and B ରେ ଫାଇଣ୍ଡିଂ କଣ ହେଲା କଣ Exhibit A B ରେ କଣ କହିଲେ
ସେଇ ଡକୁମେଣ୍ଟ
ଏଟା କୋଉ କେସ୍ ଆପଣ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି ସାର୍ କୋଉ କେସ୍ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି
କୋଉ କର ସାର୍
ଆପଣଙ୍କର ନମ୍ବର କେସ୍ ନମ୍ବର ହେଲା RPFF
ପେଜ 12 ଲେଖାଇ ସାର୍
ଆରେ ନାଇଁ ନାଇଁ ଇଆଡେ ଅନା ଆପଣ ଡିସଓରିଏଣ୍ଟେଡ ଅଛନ୍ତି ମିଷ୍ଟର ଦାସ ଲୁକ୍ ଆଟ୍ ମି ଆପଣ କେସ୍ ନମ୍ବର କେତେ
180
180 go to the judgment page 4 ଯାଆନ୍ତୁ 4 କୁ ଯାଆନ୍ତୁ judgment page 4
page 4
ଚାରି ପାଉନାହାନ୍ତି
ହଁ
ଦେଖନ୍ତୁ list of exhibits proved by the respondent କଣ list of exhibits fourth line ହଁ list of exhibits proved by the respondent
page 4
ସାର୍ ତୁ ବହି ଫାଇଲ ଆଣନ୍ତୁ ମତେ କାଢିବାକୁ ପଡିବ ଦିଅନ୍ତୁ ସାର୍ ଦିଅନ୍ତୁ ମୁଁ କାଢିଦେବି
ଦେଖୁଛି
ଆପଣ ଆଉ ଗୋଟେ କଣ ଖୋଜୁଛନ୍ତି କଣ
ଏଇଟା ଧରିଛି
ପାଇଗଲେ ତ 4 ନମ୍ବର ଲାଇନ ଟା ପଢନ୍ତୁ ଜଜମେଣ୍ଟ ପେଜ 4 ଲାଷ୍ଟ ପେଜ ଟା ଜଜମେଣ୍ଟ ର ଲାଷ୍ଟ ପେଜ ଅଛି 4 ଆପଣ ଏବେ ଫେର ଆଉ
ଡିକ୍ଲାରେସନ
ସାର୍ ନାଇଁ ଡିକ୍ଲାରେସନ ନୁହଁ ସାର୍ ମତେ ସିଧା କହିଲେ ଆପଣ ମତେ ଦିଅନ୍ତୁ ଫାଇଲ ଟା ଆପଣ ପାଇବେନି ମତେ ଦିଅନ୍ତୁ
ଜଜମେଣ୍ଟ ର
4 ନମ୍ବର
Judgment page 4 টা দেখুন।
Page 4.
ଆପଣ ବନ୍ଦ କଲେ ଯାଇ ସାର୍ ଆପଣ ଖୋଲିକି ଦେଇଥିଲେ ଆପଣ ବନ୍ଦ କରିଦଉଛି। ଆନେକ୍ସ ବି କରିନାହାନ୍ତି ଆପଣ ଯୋଉଟା ଇନକ୍ଲୁଡ ଅର୍ଡରଟା କେତେ ଆନେକ୍ସର?
ଗୋଟେ ଆନେକ୍ସର ସାର୍।
Annexure 1.
ଆନେକ୍ସର 1 ତ
ঠিক পিটিশনের পরে পড়েছি স্যার রিভিশন পিটিশন
ନାଇଁ ନାଇଁ ଆପଣ ଟିକେ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁ। କୋଉ ମ୍ୟାଟର 180 ମିଶୁନି ନା? I was looking at other page. It is good that
লাস্ট পিস আর ডকুমেন্ট লাস্ট পিস এবি কি লাস্ট হচ্ছে স্যার এবি কি লাস্ট হচ্ছে
তো ସେଇଠୁ ଏକ୍ସିବିଟ୍ କଣ ହେଲା?
স্যার দেখুন এক্সপিরিয়েন্স কোন লেখিছি
ନିଅନ୍ତୁ ନାଇଁ ସେଟା ଜଜମେଣ୍ଟରେ କୋଉ ଡିଲ୍ ହେଇଛି ଦେଖନ୍ତୁ।
সেটা লিখছি স্যার
ଜଜମେଣ୍ଟକୁ ଯାଆନ୍ତୁ।
দেখুন প্রথমে দেখুন স্যার এটা দেখুন প্রথমে দিস ডকুমেন্ট earlier to this order of my lord, the 125 or this Hon'Ble family court has taken note of this document while passing the decree of divorce.
Para 25 पढ़ो पेज 48 को जाओ 48 पेज को जाओ para 25
सेटा उठ लाइन में क्वेश्चन once
प्रॉब्लम होबा आपण जेते लाइन कहिबे
मैं कहबे नहीं एरो
पढो जदी कंसंट्रेट करिवेनी ट्रायल कोर्ट जजमेंट
एरो कंसंट्रेट करबी सर आपण को एरो करबी
सो 25 पढो तो
पढी सर एतो पढी it is that 24 तो सर 24 से मेंशन है सर देखो
पेज को तो पेज
23 देखो सर हां
23 रे कोन अछि 23 कोडा माने जजमेंट पेज ना रनिंग पेज
जो एग्जीक्यूटिव सर डॉक्यूमेंट सर पे लिखा है
Judgment page.
जजमेंट पेज 23
जजमेंट पेज 23 देखो
And running page.
मोर रनिंग पेज 40 हो 40
हां कोन हला
देखो this said document was executed on 4/6/2025 25 and the OP and the father of the petitioner
से सर देखला पर मु टिके आगवा फास्टर जाउछ नॉल बिकॉज़ वी आर टाइम रनिंग शॉर्ट ऑफ टाइम हमें गोटे पेज पे 10 मिनिट खर्च कर सारी
से पेज पढी सर
सेटा तो सर इट हैज बीन मार्क्ड एज एग्जिबिट बट आपण गोटे डॉक्यूमेंट प्रूव करचंती
मोर
हला
आपण लाइन को दे सर
आपण पेज आपण पारा 25 को जानतु तार फाइंडिंग दा देखिबे
हां फाइंडिंग
20 इज नॉट द फाइंडिंग
हां 25 है सर 25 ऑर्डर पढ़ो सर
टिके सुनंतु कि 41 को आसंतु
41 41 पेज सर
हां
ठीक है सर और लेख हां आसे जा 41
यू आर राइट फाइंडिंग अच्छी
सर
हला
सेडी आउ डिस्प्यूट होउछन से
अरे से डिस्प्यूट करे जे फाइंडिंग को डिस्प्यूट कोछन अपन से अपन पार्टी ते गडो अपोजिट पार्टी पढिबे ना
ऑर्डर पढिबे
हां so far as the अपन आउ केते पेशेंट कोड पाइबे
नो अदर पर्सन
ना so far as the document टी मिस्टर प्रधान so far as the document बाहर करले सेटी देखेले
Page 41.
इंटरनल पेज 23 so far as
20 ओ अपफ्रंट ये बोल्ड को हां yes
So far.
so far as
so far as the document order is concerned, the content of the said document shows that the petitioner left her in law's house as per her own will and not willing to maintain marital relationship with OP. the execution of the said document is disputed by the petitioner. Therefore, it is the onus of the OP to prove the contents of the said document as per law.
अरे पढ़ुनाहांती मफे अटकिले काहेकि आमे तो ऑलरेडी 15 मिनिट पळेला पहुंची
Marking of document as agreed will not in no way exempt the OP to prove its content under Section 67 of the Evidence Act and its execution. Allegation
सीट रही जाते आपण कंटेंट्स ता प्रूफ करथिले कि एग्जीक्यूशन प्रूफ करथिले कि
by
प्रूफ कले
by the petitioner by the OP
प्रूफ कले who is the witness of executant को साक्षी करथिले कि आपण एग्जीक्यूशन टा को प्रूफ करथिले
by the OP who filed the said document.
से डॉक्यूमेंट एग्जीक्यूट किए करथि
execute document execute the
petitioner execution केमती प्रूफ है execution of a document केमती प्रूफ है 67 रे
सुन थोड़ा कोई
अरे फिर सुनेले आपण तो सुनो सर
by this scribe होना कोनी by this scribe प्रूफ करी
स्क्राइब प्रूफ होबे विटनेस प्रूफ होबे execution has to be
लिखित हो जे
राइट सुनो तो ठीक है अटेस्टिंग विटनेस को आनिबे प्रूफ करिवे सेक्शन 67 ऑफ एविडेंस है सेटा आपण करी नाहंती
सेते देखो
सर मु कोन देखिबे सेते सेटा आपण हेडी ट्रायल कॉल करथिले ना मु करथिल तापर पढंतु allegations of assault the OP to prove its contents under section 67 of the Indian Evidence Act who पढि देउ आपण स्लो हो जाउछन पहिले ऑलरेडी गला डिस्कस
who had sold the stamp paper on which exhibit A has been scribed is not examined.
Yes,
by strongly it is found that
strong no very strangely
it is found that the signature of the petitioner in the reverse side of the exhibit A has been mentioned as Sujata Hui. Again, Sujata Hui. The letter has been
overwritten.
It is also not understood when all the parties are present in the PS until that subject.
परंतु आपण जेतेबेले गोटे फिजिकल एक्ट प्रूफ करिवे सर गोटे डॉक्यूमेंट प्रूफ करछन यू शुड नॉट हैव आपण सिंपली विटनेस दवार थिला तो नो केस डिसमिस्ड सर नो केस डिसमिस
सर मोर फुटेज माय सबमिशन इज
सर एते सुनला परे आई कैनॉट सिट ओवर
ओनली वन लाइन once an order passed by this same court, my lord, in family court of the same rank at Hon'Ble, and
सेटा आमे एठी तो भाषण दोने ना
नहीं से
मो कथा सुनुत आपण जोटा कहउचंती जदी किछि केस लॉ अछि दैट जजमेंट इज बाइंडिंग आपण को प्रॉब्लम हैला जे आपण काहे की एग्जीक्यूटिव ए प्रोड्यूस करले काहे की प्रूव करलेनी सेटा आपण जानचंती
आज्ञा गुटे
फिर आज्ञा कहले आपण गोटे सेंटेंस करया को देबेनी you have produced exhibit A for certain purpose. You did not prove exhibit A. The onus is on you. The onus is on the party who produces the document. Interestingly, you want desertion by the wife to be proved by a document, which is a very unusual thing. Let us assume आपण को कोन इच्छा हला कि वकील आपण कहले whoever आपण निजे करथिले केस आपण ट्रायल करथिले एटा काई एड्यूस करथिले सेटा you should always take care of marking those things are as evidence where you can prove it. आपण जदि कहिले जे that the other court's judgment is binding on the 125 court सेटा कोठी आर्गुमेंट करछन को केस रे कहला
sir in CP case I have rely on that document in the family court and
that was the problem आपण CP रे जोटा रिलाय करले
that has been
unfortunately सेटा को एथिरे एड्यूस मार्क करले प्रूव करलेनी
से डॉक्यूमेंट फाइल करी सर से जजमेंट फाइल करी
सर जजमेंट रे हेई परिबोनी एटा आपण को एटा कोन इंडक्शन ऊपर ना कोन इंडक्शन रे हेई जिवो सेमिति वेनी you have to should have proved exhibit A before the 125 court
that in that
you have not you have chosen no case dismissed if you want admission paisa deposit karantu I may consider because you see after discussing so much in the court this is court's valuable time sir आपण इंस्ट्रक्शन नियो तो डिपॉजिट करिवे 4 लाख टका ताले नोटिस इशू हो that is not of the concern आपण इट्स सर मु एटी प्ली बार्गेनिंग नो डिक्री बार्गेनिंग आपण मु देई परिबेनी सेटा कहले मु कोन करी कोन देबे कि
सर इंस्टॉलमेंट आई विल पे इन इंस्टॉलमेंट आई डोंट
नो इंस्टॉलमेंट सर आपण देई होबनी आपण को इंस्टॉलमेंट देबनी काहे आपण यू आर ए रैक डिफॉल्टर You are a rank defaulter in paying the maintenance.
Sir,
please examine the case law on this.
Yes, sir.
आपण केते टका देबे बुझी के आसंतु. I am not passing any order. The lauded counsel for the petitioner was had at length.
My lord,
He has taken the judgment of the learned trial court was placed learned just family court in ete. Sorry. The husband in the marriage is the petitioner in the
my lord,
present application.
my lord, you also will attend the case to United, my lord, I'll file a decision of this. I'll file a decision of the Supreme Court in this matter.
Nothing. Decision ମୋ ପାଖରେ ସବୁ ଅଛି ସେଟା ନ ଭୁଲିଲେ କେମିତି ହବ ଆପଣଙ୍କର
I have brought two decisions. My lord, I have brought two decisions.
no decision is there, sir. Don't be overconfident in misguiding a court.
No, I'm not
ଆପଣ ଶୁଣନ୍ତୁ listen, sir.
Sir.
Don't get disoriented. ଆପଣ ଗୋଟେ problem ଅଛି ଆପଣ କେବେ ଧ୍ୟାନ ଦେଉନାହାନ୍ତି।
ଶୁଣୁ ସାର୍ ସୁପ୍ରିମ କୋର୍ଟ decision ଆଣିଛି
କୋଉ decision କହୁନାହାନ୍ତି।
ଏଇଟା ଦେଖନ୍ତୁ ସାର୍ ଏଇଟା ହଉଛି 2025 SCR page 462.
ହଁ କୋଉ ପାରା କାଢ
ହଁ ଦେଖନ୍ତୁ
କାଢ
ଏଥିରେ କଣ ଅଛି ସାର୍ ହଁ
Off marle difficult, sir. Very difficult. Actually, I am very strict in whoever is bluffing before the court.
Mere thing. I'm just ଦେଖନ୍ତୁ
କୋଉ paragraph ଆପଣ ରିଲାଇ କରୁଛନ୍ତି କହିବେ ନା ମୁଁ ଦେଖିବି ସେଟା କୋଉ paragraph
front of cross of the front ଯୋଡେ
leave habit of reading headnote ପଢିଆ ଛାଡନ୍ତୁ case ପଢନ୍ତୁ
ପାରକୁଲ ସାର୍ ପାରକୁଲ
let us not make it a
your lordship decision also followed Swami Paruki versus Soikai that also followed in this area. In this decision that has been followed.
ଆପଣ କୋଉଟା ରିଲାଇ କରୁଛନ୍ତି ଏଟା ଲର୍ଡସିପ ପିଟିସନ କେମିତି ଏଟା ସୁପ୍ରିମ କୋର୍ଟ ଡିସିଜନ ଟା ଆପଣ
ସୁପ୍ରିମ କୋର୍ଟ ସାଇଡ୍ ସେଇଟା ଫଲୋ କରାଇ ସାର୍ ଏଟା another content that the art of before this house is that the finding in the judgment of justice
କୋଉ paragraph ନ କହି ଆପଣ ଫେର ମତେ ଅଟକି
paragraph 30 ଦେଖିବେ paragraph 30
ହଁ ଦେଇ ଦିଅ ପଢ now let me complete the order आप सर मैं नहीं आज्ञा
सर काली की
आज्ञा किछि न करी हमें 25 मिनिट नहीं गले आज्ञा
सर एटा काली की रखनो पढी की
अरे आज्ञा काली की रहइबो जे आपन को डिसमिसल को दिन हो डिसाइड करो
काली जा करिबो सर
ना ना पैसा डिपॉजिट करिवे कि आपण काली
ये थोड़ी पढ़ी आपन मार्क करके दे मार्क करनी तो मार्क करके दे सुविधा हो
पैसा डिपॉजिट करिवे कि
आज्ञा
पैसा डिपॉजिट करिवे
कहबर कि डिपॉजिट करी सर
हां 4 लाख टका देबे
4 लाख दे परिबिनी सर मु दे
आपण 10,000 रु आरंभ करछु
एलपी स्कूल मास्टर 10 जानि लक्ष बोले नाले एटा मु पढी काली समय चली एवं
आपण तो पचारंतु कोर्ट कहउछन 4 लाख टका ना डिस्मिस होबो से केते कहिबे आसंतु
काली की आपण रखन हम एटा पढी आपण देखै पूरा अछि अछि इतरे हेई परिबनी 124 लेखा हैनी खाली से पर जे गोलानी बोले एटा अलगा मैटर बोली से
अरे एटा तो आपण एगेंस्ट डिसीजन
एटा इतरे
आपण 125 4 प्लीड करथिले कि
कुटी हां
गाइस
पिटिशन देखा प्लीड करथिले सर ए देखन तळकोट प्लीड करथिले सेते डिसीजन देखिथिले से पळे गला बोली देबिनी बोली कहिछि सर अछि जजमेंट ए ऑर्डर अछि तळको पळे
एटा आपण एगेंस्ट एटा काई साइड करछन
इतरे सर काहे साइड करते
सुनो तो आपण होल प्रॉब्लम हला आपण जेतेबेले पढिबेन यू डेवलप a habit of not reading anything
सर
तार प्रॉब्लम कोन हो ना आपण डायरेक्ट एगेंस्ट जोडा सेटा आपण सेट कर
एटा मु
पढि जने कोन लेखा हिची सुनंतु मु जा कहबी सुनु से कहले डिस्क्वालिफिकेशन अंडर व्हेन नॉट अट्रैक्टेड
हां नॉट एटा अलगा
कॉपी बार हो गले
आपण कहि सर मु कहबी
सर नो मोठी आपण किछि कहूनी God has given you ability to listen and understand.
हां सर कोंतु
कहि की बुझिवेनी
हां
कोन you have lost the habit of listening
कोइ मुई सालेनी एटा मोर केसेस शूट करूनी बोले एटा कोइ
नो आपण डायरेक्ट अगेंस्ट द पॉइंट यू आर सेइंग सेटा सुन सेटा आपण पढि की सुनो
हां कोइ सर
a decree for restitution of conjugal rights obtained by respondent number 1 husband non-compliance therewith by the appellant wife if would be sufficient to attract disqualification of copy बार मकले
एटा मो केस
मो बुझी आपण सुनंतु
कोन सर
125
सेटा मु कोइ
हेल्ड नो
सर एटा काहे एटा ए केस है अलगा केस ए मो केस को शूट कर मो केस कोन सर
करि दे
125 4 को डायरेक्टली इन दैट
you have actually you have I mean given a judgment which says even non-compliance of the wife of restitution of conjugal rights will not disqualify.
In that case, my lord, here is a case why wife is
problem है जे आपण you don't आपण प्रथम कथा है
exact decision जानि
so ए डिसीजन टा नेक्स्ट पॉइंट है ए डिसीजन टा साइड करथिले कि सेठी
नहीं साइड
कर सेटा आउट प्रॉब्लम हो
नहीं साइड
दिस डिसीजन इज डायरेक्टली अगेंस्ट यू
My lord, your
ଆପଣ ତ ଶୁଣନ୍ତୁ ଆଜ୍ଞା ମିଷ୍ଟର ଦାସ ଇଭେନ୍ ସେକ୍ସନ 9 ଯଦି ଜଣେ କମ୍ପ୍ଲାଏ କରୁନି ଷ୍ଟିଲ୍
ସେଇଥିରେ କହିଛି
ଜଣେ ସେକ୍ସନ 9 କମ୍ପ୍ଲାଏ କଲେନି
ସାର୍ ଏହା ସେକ୍ସନ 9
ଫେର ସାର୍ କହିଲେ ଜଣେ ସେକ୍ସନ 9 କମ୍ପ୍ଲାଏ ନ କଲେ ୱାଇଫ ମେଣ୍ଟେନାନ୍ସ ପାଇବ ନା ପାଇବନି
ସେଟା ପାଇବ ସେଟା ସେକ୍ସନ 9
ସେଟା ଡିଗ୍ରୀ ଅଫ ଡିଭୋର୍ସ
ସେଟା ଅଲଗା ସେଟା ଅଲଗା ଏଇଟା କଥା ହଉଛି ସାର୍ 120
ସେ ଆପଣ ବର୍ତ୍ତମାନ ଆଇ ଡିକ୍ଟେଟ୍ ଆଫ୍ଟର ଆପଣ ଡିକ୍ଟେସନ ବି କରେଇ ଦେବେ The husband in the marriage.
Your lordship.
You take your seat.
Sir, sir,
don't disturb the court when the court is dictating orders.
Sir,
you take your seat.
Sir, I'll not issue. I'll pay for 1 day adjournment, sir.
No, I have cited judgment.
No, I'll cite another judgment.
Bluff marantuni.
No, problem.
If you are bluffing, you will find out a judgment. Our first judgment is directly against.
Sir, find out find out କରନ୍ତୁ ଆପଣଙ୍କର adjournment ହବ ଟଙ୍କା ଯଦି ଦେବେ ନହେଲେ କାଲି dismiss ହେଇଯିବ ପରଦିନ ହେଲା ଲୋକେ ଡିପୋଜିଟ୍ କରିବି ସାର୍ ମୋତେ
ଲକ୍ଷ ଟଙ୍କା ନୁହଁ ଏଠି ବାର୍ଗେନ୍ 4 ଲକ୍ଷ ଟଙ୍କା ଯଦି
ଡକୁମେଣ୍ଟ ସାର୍
4 ଲକ୍ଷ ଟଙ୍କା ଯଦି ଡକୁମେଣ୍ଟ ଦିଅନ୍ତୁନି I cannot look into documents ଯୋଉଟା କି in fact that principle has been followed in this district
ତାହେଲେ ଇନଷ୍ଟଲମେଣ୍ଟ ଦିଟା ଇନଷ୍ଟଲମେଣ୍ଟ
ଆପଣ ଦେଖନ୍ତୁ ଆଜ୍ଞା ଟାଇମ୍ ନାହିଁ
ଦିଟା ଇନଷ୍ଟଲମେଣ୍ଟ
ଫାର୍ଷ୍ଟ ଇନଷ୍ଟଲମେଣ୍ଟ 3 ଲକ୍ଷ ଟଙ୍କା ଦେବେ
ହଁ 2 ଲକ୍ଷ ଦେବି
3 ଲକ୍ଷ ଟଙ୍କା 3 ଲକ୍ଷ ଦେବି ସାର୍ ବାର୍ଗେନ୍ କରନ୍ତୁନି ସେ କୁହନ୍ତୁ ଡିପୋଜିଟ୍ କରିଦେବେ ପରଦିନ କେସ୍ ଆସିବ ହେଲା ଠିକ ବଟ୍ ଆଇ ପାସ୍ ଅର୍ଡର୍ସ ଆପଣ ତ କରେଇ ଦେଲେନି वी हैव स्पेंट देखो 25 मिनट in a half day's court you have spent 25 minutes
ପରଦିନ ସର୍
ଆଜ୍ଞା ଆପଣ ପରଦିନକୁ ରହିଲା ଆପଣଙ୍କ କେସ୍ ଆପଣ ଡିପୋଜିଟ୍ କଲେ ଡିସମିସ୍ ହେଇଯିବ ମୁଁ ତ କହିଲି ପ୍ରଥମରୁ ମୁଁ ଡିସମିସ୍ କରୁନି ବୋଲି ଆଜି
ଠିକ ଅଛି
I'm making a mention now. My lords, item 23 it was posted to 6-7 my lords. I am just
ଶୁଣନ୍ତୁ ସେ କଣ ମେମୋ ଦେଇଥିବେ କଣ ହେଇଥିବ ସେଥିରେ କଣ ଅଛି
I am just requesting for
ଆପଣଙ୍କର ଅଦର ସାଇଡ୍ ଆପଣ ପିଟିସନର ନା ଅପୋଜିଟ୍ ପାର୍ଟି
opposite party. I have taken permission from the petitioner.
My lord,
ଆଜି କରିଦେବେ କୋଡିଏ ସାର୍ page wise ସାର୍ ଯିବା
my lord, item 15 on behalf
ଟିକେ
of
ଟିକେ
executive.
ଟିକେ ଜଷ୍ଟ ୱାନ୍ ସେକେଣ୍ଡ ଆମେ କୋଉ ଯାଏଁ ଗଲେ 15 ରୁ 18
My lord, 15 item.
ଅର୍ଡର୍ସ ମ୍ୟାଟର ଛୁଟି ପୂର୍ବରୁ ନା ଛୁଟି ପରେ
My lord, ମାନେ ଆଇଏ ଫାଇଲ କରିଥିଲେ କଣ୍ଡୋନେସନ ଡିଲେ ପାଇଁ ଆମର ଅବଜେକ୍ସନ ଥିଲା ଅଫିସ ମାନଙ୍କୁ ସର୍ଭ ହେଇଯାଇଛି my lord delay may be condoned along with costs.
ଆପଣ ହଜବେଣ୍ଡ ପାଇଁ ନା ୱାଇଫ କୁ
My lord, husband ପାଇଁ
ହଜବେଣ୍ଡ ପାଇଁ କଷ୍ଟ ନିଅନ୍ତୁନି
My lord, only 71 days delay under 125
then will have difficulty at home
My lord, family court completely self desertion ground re dismiss ହେଇଯାଇଛି
Madam, coincidentally the world is so small we have already heard Mr. Das elaborately discussed and he has cited a decision directly on the point that even in case of section 9 the refusal of wife to comply section 9
My lord.
will not disentitle her for compensation maintenance to that extent the apex court has gone कोंडो नहीं जो ठीक है
My lord.
आसु फ्रेश एडमिशन आसीयो ना कोन
Yes, my lord.
ओके
Item 16, my lord.
केते दिन डिले हिची
71 days.
71 आपण कॉस्ट कोछु वे ऑब्जेक्टिंग सेटिंग मु कहि देबी आपनकर 15 रे मिस ए त्रिपाठी
Yes, ma'am.
मिसेस पीके त्रिपाठी
अरुणिमा मिश्र
से 15 तो नाहंती आपण
ए बाय
आपण कोना चेंज कर दै छथि
My lord, I'm saying on behalf of advocate.
ओके ठीक अछि 15 16 17 18
I am for the opposite party, my lord. Item 16.
16 रे अपोजिट पार्टी
Again. So I am filing one objection, my lord. So I am serving one.
पिटिशनर थिले सिना
I'm for the petition.
मैडम 16 रे मिस जोस्नामय साहू मिसेस साहू आपण कोना सर
PK Nigam, my lord.
अच्छा
I am serving the.
आपण ये जो फाइल करछन्ती ऑब्जेक्शन टू आईए
No, I.
के आफ्टर वेकेशन
After no within this before
last वेकेशन है कौन डेट क्या है कितने दिन
I have also filed on I
120 टा मैटर रखि सारली
my lord because my lord
at least 30 टा मैटर तो ऐड करिवे 120 हला माने ता धरे आउरी मैटर अछि ऐड हवा पे और ऑर्डर्स एटा आसु केबे सिबो 29 रे ऑर्डर्स आसु
Interim order.
ଏଥିରେ ଆପଣ ଅବଜେକ୍ସନ ଫାଇଲ କରୁଛନ୍ତି ନାଇଁ?
ଆଜ୍ଞା ମୁଁ ସର୍ଭ କରିଦେଉଛି।
ସର୍ଭ କରିଦିଅନ୍ତୁ କପି।
Interim order ଅଛି।
Yes, yes. 17
At the stage of, why not at the stage of argument, this writ petition has been filed? Because
नहीं, argument stage रे ହେଇଛି ଯେ, but if the court has issued notice, then I mean the coordinate bench has issued notice. It has to be honored. ଆପଣଙ୍କ 24 ମସିହା କେସ୍ ଟା ନା?
ଆଜ୍ଞା ଆଜ୍ଞା।
ଦେଖନ୍ତୁ after vacation ତ ବିଶେଷ 33 ମାନେ immediately after vacation ହେଲା। ଏଟା କଣ matrimonial cause ନା କେସ୍ ଟା କଣ?
Yes, my lord, we have filed a recall petition in the court below.
Recall ଟା reject
to recall the
witness ଦେଖିବା। ସେ ବର୍ତ୍ତମାନ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି କାରଣ ସେଠି ବି ଟେକ୍ ଅଫ୍ ହେଇପାରିବନି ଏଠି ବି ଟେକ୍ ଅଫ୍ ହେଇପାରିବନି। So better to go after vacation. Interim order ଟା ସେଇ ଯାଏ ପୋଷ୍ଟିଂ ଡେଟ୍ କେବେ ଜାଣିଛନ୍ତି? ଡେଟ୍ କେବେ ଅଛି?
Date ଅଛି my lord on 15th of this month. 15th.
ତ ଏଟା ନେକ୍ସଟ ଡେଟ୍ କେବେ କଲେ? 29/6. It will be adjourned beyond the pending matters will be adjourned beyond 6-7 ଆଉ।
Item 21
ମୁଁ ଦେଖିବି କଣ ଅଛି ହେଲା। ତାପରେ ନେକ୍ସଟ ପେଜ ରେ 19 20 21 19ଟା 20ଟା ଯାଇଛି 19ଟା କଣ କହୁଛନ୍ତି?
This matter ta I ଅଛି limitation notice may be issued.
Revision for against what sir?
Challenging the quantum.
Enhancement चाहुଛନ୍ତି?
Yes.
So take notice both IA and petition take notice.
Yes.
5 days. देबे तो requisite 5 दिन रे?
Yes.
ठीक है 5 working days. केबे 19टा केबे आसीबो तारीख?
We commencing 13/7.
13/7 रिटर्नेबल हबो 1/7 कि 6/7 रिटर्नेबल? Yes. 21 Mr. Mishra?
Yes, Mr. Land acquisition appeal. Notice has to go on the question of limitation. There is delay in filing the appeal.
केते दिन डिले?
300 के दिन ଅଛି।
300 दिन डिले ହେଇଛି?
ଆଜ୍ଞା।
डिले नोटिस जाओ?
डिले notice।
केते दिन रिक्विजिट्स ପାଇଁ କେତେ ଦିନ ନେବେ?
Within 5 days।
5 रिटर्नेबल डेट केबे आए तुम्हारी?
6/7.
लिस्टिंग डेट 6/7 है?
Return.
रिटर्नेबल 6/7
13/7 we comes.
13/7 ओके ठीक है। सो सतपति भाई
item 22 मैम।
the pleadings counter हेगा अच्छी।
Yes मैम सब सर जाइछि।
एटा आफ्टर वेकेशन ही परिबा। You cannot be adjusted.
After
आपन को सर्विस मैटर इस मैटर तो इट हैज टू बी हार्ड कौन 22 डेट करंतु।
Because
27 वीक हैला सिंपल एडजस्टमेंट 22 रे के मिस्टर सेठी और प्रभु
interim order ता
anyway it is simply adjourned.
22 रे interim order ता अछि कोन?
Interim order I am not touching. If there is a stay order, only adjournment orders I have to again do it. Prabhu is now
It's on that.
Abhirbhav Heledi
It's on.
yes
item 26 lords.
23-24 23 ଆପଣ ନେଲେ 27 କହିଲେ ପରା ଠିକ ଅଛି yes
Item 25. I'm appearing for the opposite party.
yes
There is a interim maintenance there which has been stayed. And
କଣ କରିବା ସେ ତ 22 ମସିହାରୁ
stay ହେଇକି ରହିଛି ଆଉ ସେଥିରେ
କେବେ ଗୋଟେ ଡେଟ୍ ନିଅନ୍ତୁ ଆଉ
ତାର ଗୋଟେ particular typical prayer ଅଛି ସେ prayer part ଟାକୁ ଯଦି କୋର୍ଟ ଦେଖିବେ
ଏ 25 ରେ 25 ଟା ଗୋଟେ ଡେଟ୍ ନିଅନ୍ତୁ ନେକ୍ସଟ ୱିକ୍ ରେ ରଖନ୍ତୁନି सेम से रहिबो खाली से पड़िबोनी समथिंग 25 टा करंतु डेट 25 टा मिस्टर परिजा मेंशन करथिले कि ना ते आउडे मेंशन कर मिस्टर परिजा वाज देयर ही वाज मेंशनिंग सम मैटर वी कमेंसिंग 29
Item 26 lordships after vacation.
26 मिस्टर दास मिस्टर महांती वाज प्रेजेंट
Yes, sir.
डेट कर दियंतु
We commencing 29.
29 अपन को 6-7-91 हो जाईती 29-6 76 टा हेगला 76 कोन एटा कसी इट हैज रीचिंग 90 नाउ ओके ये 27 रु 30 के मेंशन करछन
28
28 सर यस
very small matter
After vacation,
vacation ପରେ ଆସିବ ଗୋଟେ date ଟେ ଖାଲି
date say we commencing ହେଲେ ଆସିପାରିବ.
one more
Problem is if once you fix a date, the list section or the court master cannot alter it. But if you make it a week, they are adjusting.
only prayer can it be under the fresh admission, it can be remanded.
No change of fee. ଆପଣ ଯେତେବେଳେ when the both parties are agreeing, just make a mention that you have agreed for disposal, it can be taken up, sir. 28 ଟା କେବେ ଡେଟ୍ କଲେ?
We commencing 13/7.
13/7. Yes. 29 to 31. 32 ଟା ଯାଇଛି.
34 37.
Then so your matter is complete. Then ପୁରାଟା complete ହେଇଗଲା. ଆଉ ଯେତିକି ରହିଗଲା by chance posting କରିଦିଅନ୍ତୁ. At least ସେତିକି they will be satisfied that date ହେଇଗଲା.
सुनील कलित
ଆଜ୍ଞା ଆଜ୍ଞା
କେତେବେଳେ ଦେଖନ୍ତୁ
sir ଆପଣଙ୍କ ମ୍ୟାଟରଟା sir ନମ୍ବରଟା
24.
After vacation
ମାର୍କେଟ ଭେକେସନ ବହୁତ ସଫଳ
ନାଇଁ ହବ ମାନେ ଆଜ୍ଞା ଲିଷ୍ଟ କରି ହବ but it doesn't lead to anywhere. ଖାଲି ଗୋଟେ impression ଯେ ହଁ ଲିଷ୍ଟ ହେଲା but ପଡିବନି. କେବେ ଡେଟ୍ କରିବେ 24?
29/6.
Week commencing 29/6.
28
ହଁ ମାନେ ଆପଣଙ୍କର
ଫାର୍ଷ୍ଟ ୱିକ୍ ଟା ପରେ
ହଁ ରିଓପନିଂ ର
ଫାର୍ଷ୍ଟ ୱିକ୍ ଟା ସେକେଣ୍ଡ ୱିକ୍
ହଁ so there is a noting that it will continue after the other bench, but that will become difficult for lawyers also. Because yesterday that matter continued till 4:30.
So somebody knows this.
Right. And this past orders were those were matters taken up. So only those orders will be passed.
27 my lord.
27 date कर दिया
We commencing 6/7. 6/7.
I'm for opposite party.
ऑर्डर किछि सिंपल एडजर्नमेंट माने कंप्यूटर रे जोड़ा हे जाउछ.
Item 14.
14 आरंभ हो. Mr. Ashwini Kumar Das for the petitioner. Mr. Rajendra Kumar Pradhan for the opposite party. Just before I begin, Mr. Lenka.
Yes, sir.
So did you examine those
Yes,
decisions?
Yes. But those are not applicable. I have
You are
brought
saying that you are not; those are not applicable. So no, if you say that, I'll record your submissions that notice to the power of attorney holder is sufficient notice.
Yes. That is
So no. Like this, I'm just thinking aloud. In fact, I am not hearing also because I'm dictating something else. Since I was not looking at that side,
the act itself provides the effect of notice.
Which act?
Partnership.
No. Partnership Act is very clear, sir. Partnership Act is very clear. I have studied that to a certain extent. Your argument has to be rejected. There is no case law, nothing. Section 4, Section 5, read with that what I mentioned those.
No, I have brought a case law, Section 4. Today.
ଆପଣ power of attorney ଟା power of attorney जोटा ଆପଣଙ୍କ argument ହେଲା since he was the power of attorney holder. Notice to the power of attorney holder, even I pointed you out that who will be the agent in case of a partnership firm.
In what?
Section 18.
Yes.
Section 18 is that partner to be agent of the firm. So, but your argument is that there are two ways of looking at it. Suppose I will record your submission and pass, because I have been discussing, I am thinking aloud. I could have very well reserved and then passed orders, but I am bringing to your notice so that you can, point out what are your views on that, whatever we have been discussing.
In our case, the power of attorney holder is also a partner.
Correct, sir. Correct. Power of attorney holder is a lessee, is a co-lessee I pointed you.
Co-lessee,
So that is how I told you that why the language co-lessee is being used. And nothing prevented you from issuing notice to all the lessees. Nothing. Because you are saying that we have not issued, but we have issued notice to the power of attorney holder.
Yes.
Now even if suppose I am observing that, I'll still be remanding.
No, that is your lordship's prerogative.
No, not prerogative. Not prerogative. No, Mr. Lenka. I am talking about the consequence.
Yes.
Suppose now suppose I am not going into that. I am not going into that aspect whether notice is sufficient or not, but I will be directing issuance of notice also. That I wanted to tell you.
I will only show your lordship with 3 or 4 sections and the judgment.
There is none of the sections. There is none of the section. The law has not evolved that notice to one of the partners, assuming that he is a power of attorney holder, is power of attorney notice to everyone. Correct.
Section your lordship is section 24 of the Partnership Act. Effect of notice to acting partner.
So you have answered me.
No, this was not brought your lordship.
No. Acting partner, you are yourself saying.
Who habitually acts in the business of the firm of any matter relating to the affairs of the firm operates as notice to the firm.
Read.
Except in the case of fraud on the firm committed by or with the consent of the partner.
So that answers again the problem. So that is how I told you. That is how I told you that then you have to first of all prove these things. Who habitually acts in business of the firm of any matter relating to the affairs of the firm operates as notice to firm. Now this is a OPDR proceeding. So you have to show that he was dealing with that OPDR matter for the firm and he was relating to the affairs of. So this was we discussed in towards the last page. In that this power of attorney could not have contemplated a OPDR proceeding because the power of attorney is regarding the mining lease.
Not only
they are the lessee.
Everything.
Whatever. Lessee. So when you initiated the OPDR proceeding, now the question comes whether notice to the attorney holder in a OPDR proceeding will be noticed. That you have to consider. So that should be your argument. So in that context, you also must consider that section 24 deals with habitually acts in the business of the firm. That you have to prove. So all those things, so now if I direct issuance of notice to the affected parties, you may still choose to issue notice to the power of attorney holder or whoever you like, because I cannot direct that. In this sense, I can direct, but I am not going to those details. So what I was telling you that even if I reject, still I am with you. As far as remand of the matter is concerned, is a open remand. So that you rest assured that I am not interdicting your action in accordance with law to recover the money, whatever is the legitimate due to be paid to the government, and by whatever legitimate means, of course, in accordance with law. So you may take coercive action, or you may initiate a proceeding, or you may whatever. That is your choice, because to that extent you can be rest assured that this court is not interfering, which I have made when I started hearing this matter, this observation. May not be in so many words today I am telling, but that day I told Mr. Palik that if it will be remand, then like the other matter, all questions have to be argued before the and because in your case, since it is the original case, not appeal stage, so you can always issue notice. then always issue notice. That is your choice.
I have brought some citations. Yes,
No, what? And you have a citation that partnership firm is a legal entity.
No.
Contrary to 1970, that 87 Supreme Court and 2002 Volume 3 SCC. But that is the basic concept of partnership. In fact,
but they are
the law is
jointly
the law is that
liable to pay.
Company is a less company is less because this could have been possible in case of a company, authorized agent of a company. Now, because and moreover, you are not relying upon any subsequent document. Your only case is that since the power of attorney holder entered into agreement, signed, so notice to him is sufficient to all the lessees regarding the mining dues. That is your case.
Yes.
It is not that 24 who habitually deals with the affairs of. So there are case laws on section 24. There are case laws also. Anyway, we will hear it. So the a party for the Ashwini Kumar Das for the petitioner, Mr. Rajendra Kumar Das for the opposite party. The learned counsel for the petitioner is heard at length. The husband in the marriage is petitioner before this court seeking revision of the judgment dated 362024 passed by the learned judge, family court, Hon'Ble, in CR.P. case number 142 of 2019. The petition under section 125. The petition is CRP. The CRP number 142 of 20. The said CRP was initiated by the wife in the marriage under section 125 of CRPC. Seeking monthly maintenance at the rate of rupees 10,000. 125 bracket लिख देवे since it will complete कर दे. Seeking the petition was favored. However, granting monthly maintenance at the rate of rupees 4,000 per month towards 4,000 per month from 11/12/2015 till 31/12/2022 and from 1/1/2023 at the rate of 7,000. The area maintenance was directed to be paid from 11/12/2015 up to May 2024 in 4 equal consecutive monthly installments, starting from June 2024. Seeking revision of the judgment, it is submitted by the learned counsel for the petitioner. That the learned trial court has not, the learned judge family court has not examined the evidence on record in its proper perspective and arrived at a erroneous conclusion. On being asked, it is submitted that the petitioner remains in default in paying the amount directed. The defaulted amount comes to पूरा हिसाब करते हैं जो ऊपर रहला नहीं फर्स्ट जो जितनी के रहला 4000 तापरे from the date till today माने मई 2026 से को कर दे पारा The Lord counsel for the petitioner refers to the judgment, evidence judgment, particularly the exhibit marked as A produced by the petitioner herein, who was the opposite party. Regarding the said exhibit A, the Learned Judge Family Court has discussed in detail as well as the exhibit B. Exhibit A और B टा कौन लिखी है? Last page the judgment exhibit. The details of the exhibits are indicated here. The discussions and findings of the Learned Trial Court, the Learned Judge Family Court, is at paragraph 20. Which are reproduced here. Put it up on a chocolate purchase code for the regarding the income of the petitioner, the Learned Judge Family Court has gone into the details of the evidence. And the discussions and findings are paragraph 21. The Learned Trial Court has, the Learned Judge Family Court has relied on the following decisions. पूरा citation टा खाली देबे para 22, 23. पूरा quotation न करके citation दियो. 23, 24. इनको लिखे देबे following decisions of this court, of this court and Supreme Court. जितनी हला से citation टा देबे para. In view of the Hon'Ble Apex Court has Apex Court in Samima Faruqi versus Sahid Khan has dealt with. से जो अपना decision में शोड़ा copy paste है जो ठीक है ना copy. Now the Learned Counsel for the petitioner relies on the decision of the Hon'Ble Apex Court reported in Hon'Ble Apex Court in Rina Kumari. Pura लिखी है. Okay, so and so. तापरे colon to bracket colon AR 2025 SC 644 colon 2025 into bracket 2025 3 SC 33. The decision rendered in Rina Kumari does not come to the aid of the petitioner in as much as it has been held that even in case of a grant of decree of restitution of conjugal rights, in an application filed by the husband, even if the wife is not complying the said decree, still she is entitled to receive maintenance under section 125 CRPC, and section 125 into bracket 4 would not be a disqualification for receiving maintenance. In considered view of this court, the petition is devoid of any merit, as has been discussed above, in view of the law laid down in Sabima Faruqi versus Sahib Khan, Sabima Faruqi Supra, and cannot be interfered by exercising jurisdiction. So, a revisional jurisdiction of this court. Stop. At this stage, the Lord Counsel for the petitioner seeks adjournment to obtain instruction as to whether the petitioner will deposit the amount due before the learned executing court for sustaining the challenge. Accordingly, to grant a further opportunity, the matter shall be listed for as to be mentioned on on 14/5/2026. Listed mark as to be mentioned. Test.
Item 15.
A Tripathi for the petitioner. Mrs. A Misra on behalf of Akshay Kumar Pandey for the opposite party. IA 418 of 2024. The IA has intellectually the hard learned counsel for the petitioner and the opposite party. The IA has been filed IA has been filed seeking condonation of reported delay of 31 days in filing the revision application. Hard learned counsel for the petitioner. Referring to the IA supported by affidavit is submitted that sufficient ground has been shown for condonation of delay and the delay may be condoned. The learned counsel for the petitioner opposite party opposes the prayer for delay. Having gone through the causes shown in the IA explaining the delay, this court is of the opinion that adequate cause has been shown. The delay of 31 days is not much and has also been explained. Stop. Accordingly, the IA, the delay of 31 days in filing the appeal, filing the revision is condoned. IA is favored and disposed of. The matter shall be listed for fresh admission in the week commencing. 15টা ডেট করতে হবে কি 15টা ডেট
We commence on page
29 ঠিক Yes.
Item 16.
Ms. Josnamohi Sahoo for the petitioner. Mr. P.K. Nigam for the opposite party. IA 5974 of 2024. लिखि दियंतु. The objection on behalf of the opposite party has been stated to be filed. Copy has been served. Stop. The matter shall be listed for orders on in the week commencing 6/7/2026. The interim order as an interim measure, it is directed the CP number 49 of 2022 pending before the London Judge Family Court Paralakhe Mundi shall be adjourned beyond 13/7/2026 upon a prayer being made for the said purpose. There's another 6/7. The matter shall be listed for orders in the week commencing 29/6/2026. Yes, next.
19.
Mr. Subhash Chandra Sahoo for the petitioner. आइए 115/2026. The petitioner challenges the judgment dated 25/11/2025 passed by the London Judge Family Court Jaipur in criminal proceeding number 124/2023. Petitioner is the wife in the marriage. Petitioner is the wife in the marriage. Challenges safety. Seeking revision of so and so. Perhaps. The criminal proceeding was initiated by the wife in the marriage under section 125 of CRPC and two minor children born from the wedlock. So that was children of the Arabo लिखना has to opening sentence code. Now, the petitioner are the children, two minor children born from the wedlock, represented through their mother guardian. Are before this court seeking revision of so and so. Therefore, the said CRP was initiated by the children, represented through their mother guardian, seeking maintenance, monthly maintenance under section 125 CRPC. Okay. The petition was favored. However, maintenance the amount of that is seeking maintenance. The application was favored, however, nahi. directing payment of maintenance at the rate of 3,000 to each of the child per month from the date of filing of application, that is 25/9/2023. It is submitted by the learned counsel for the petitioner that the quantum of maintenance granted is less compared to the income of the opposite party father. Stop. So notice to the opposite party along with this order. Requisites for issuance of notice be filed. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 working days. Returnable date be fixed to 6/7/2024. The matter shall be listed for orders in the week commencing 13/7/2024. Yes, next.
21.
Mr. Vibhuti Bhushan Misra, Senior Panel Counsel for the appellant. The appellant East Coast Railway, represented through its officer, is before this court by filing the appeal challenging the judgment dated 23/8/2024 passed by the Purata Likhiya presiding officer, land acquisition, Lara land acquisition, rehabilitation, resettlement, so and so, Sambalpur. In land acquisition case number 314 of 2022. The proceeding before the LAR court, LAR and RA arose out of a reference under section 64 of the RFCTLARR Act 2013 made by the special LAO Salegaon Budhapong Talchet Joropoda, 3rd and 4th line project, Ekanad, for enhancement of quantum of compensation awarded to the present respondents land users. The acquisition was pursuant to a notice dated 27/2/2019 by the appropriate authority. Issue notice in the IA seeking condonation of delay as well as the appeal. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. Returnable date be fixed to 6/7/2024. The appeal shall be listed for orders in the week commencing 13/7/2024. State party के लिए copy दो पूरे. Extra copy of the appeal memo shall be served on the opinion of pro forma on the learned counsel for the state, appearing for the pro forma opposite party number 4, special LL. Yes, next. Chala. Yes, Mr.
Special item 1.
My submission would be that I'll be praying for a remand to stage of issuance of notice for the demand notice. That's
And they can raise all.
So since you had in fact mentioned that you will not be available initially, but I had my hands are full, so I was dictating.
No,
I was discussing with Mr. Lenka.
Malad.
What I drew his attention that whether I am accepting his contentions regarding sufficiency of notice or not, I will still be remanding the matter. It will be open remand, allowing them to
Everybody will resolve contentions. Yes.
So he not be anxious that whether I will decide now whether the because
no observations from your lordships.
No observation. I understand, but since he is arguing, and he has pitched it up a little high, that sufficiency of notice to a power of attorney holder is notice to the.
Then we'll have to go into the
partners.
Then we'll have to go into the power of attorney, then the lease deed, covenants,
everything. So even in that scenario also, even if I am deciding, but still I will make it. So that whether I will record those things, so that is his choice. That I asked in your absence. Your learned junior, I think she was there. So in that context,
that's what we were discussing. That if he raises that, it's just that point, then we have the answer. We have our submissions to make.
So, Mr. Lenka, I will record that your submission, but without any observation, I will remand it. Yes. And I'll definitely have to record because it is his response to your submission.
I'll record my submissions.
But could you find any decision that which differs? I mean, which gives a different interpretation of Section 4(5) that AR 80 Supreme Court 176 that legal partnership is not a legal entity. And reiterated in 2003 to SEC 349. 2003
reiterates that.
Comptroller Director General, and that is also Malabar Fisheries.
A farm is only a compendious name given.
There was a dispute regarding empanelment of professional chartered accountants. That a dispute was there. That I have gone. So whether they invited applications for appointment of professional chartered accountants having partnership firm. So the case, one chartered accountant, proprietary firm, they challenged that advertising. That was the case for them. I have brought that decision, Your Lordship.
No, sir. Let us not go into the facts. The 1980 Supreme Court, Malabar Fisheries, because this is a basic, this is taught in law school. These questions are asked in the Business Association Paper 1 examination. Yes. That the kind of business relationship, why it is called a dangerous relationship. Because you don't have the protection of doctrine of corporate wealth. That is one way of. Yeah. So I think, Mr. Lenka, still the law is that it is not a legal entity.
No. I bow down to that.
So there lies the problem. So once you say.
But if you import the provisions of NIA Act, there is a provision. Partnership firm is also a company.
Generally, especially was non-derogate. ବର୍ତ୍ତମାନ ବି NIA Act ଆସିଗଲାଣି ଯେ ଆପଣ ସେଥିରେ ଲାଟେଷ୍ଟ ଡିସିଜନ ହଉଛି the director cannot be held responsible. ସେ କ'ଣ କରୁଥିଲେ ନା ଚେକ୍ ଇସ୍ୟୁ ହେଲା ଆପଣ ଡାଇରେକ୍ଟର ଆପଣ ଚେକ୍ ଦେଲେ ପାଲିତ ସାର୍ ଆପଣ କିନ୍ତୁ ଇସ୍ୟୁ କରିନାହାନ୍ତି କମ୍ପାନୀ ଦେଇଛି ଠିକ ଅଛି ସେଥିରେ କ'ଣ ହଉଥିଲା ନା ସେଥିରେ ଆଜ୍ଞା ଦ୍ୟାଟ୍ ଇଜ ଇଭଲଭିଂ ପାର୍ଟ ସେଥିରେ ଆମର ଯିବାର ନାହିଁ ଆମର ବେସିକ ଆମର we are on a very fundamental issue.
Then I'll place your lordship section.
नहीं ଆପଣ जोटा प्लेस करूचंती सेक्शन 24 हां नहीं आपण एटा आपण इम्प्लिकेशन देखिले कि जोटा हम आपण काली देखौतिली agent defined
189 contractor
and also
commissioner income tax होता है
ଆପଣ ଯୋଉଟା ଏବେ ଆପଣଙ୍କୁ chapter 4 relation of partners to third parties, because I think that becomes relevant in view of your
yes
submission. 18 ଯୋଉଟା ଆପଣ ଦେଖୁଥିଲେ
18 actually the partner to be agent of the firm subject to the provisions of this act. A partner is the agent of the firm for the purpose of the business of the firm.
So you read 18 and 2E together.
Yes.
2E says if it is something is defined in section this act, then contract act will not be applicable.
Yes.
So even 189, even if your agency you are bringing in, but that cannot override 18.
Because the act itself provides.
And interestingly, Mr. Lenka, what they say, they have issued notice to not a partner, to a power of attorney holder.
It is also a partner.
Correct. So that is your argument now. Even to that extent also they are not agreeing.
Then
the whole concept of notice to the power of attorney holder, because I don't know exact why the reasons I cannot say, because it can't be second guessed. Why they have opted to issue notice to the power of attorney holder and not the lessees. Yes, so even 18, now we discussed 189.
Yes.
No reasons have been given also in the order. In the order also no reasons.
Wait for
Then 19 implied authority. ଆପଣ implied authority ଉପରେ ବି rely କରୁନାହାନ୍ତି. ଆପଣ କହୁଛନ୍ତି ଯେ power of attorney holder. ଆପଣ ଯୋଉ citation ଦଉଥିଲେ କୁହନ୍ତୁ.
Yes, sir. On section 24. Good. Sir. The last.
ଆପଣଙ୍କର best point କୁହନ୍ତୁ ଯୋଉଟା କି a power of attorney holder of a partnership firm, because these are the general propositions. In fact, I have no issue there. If these points what you have summarized regarding power of attorney is sufficient.
Yes.
But now you have to overcome section 18. Because it says the partner is a agent of the firm, but you are saying power of attorney holder is the agent of the firm.
Yes, I have that.
So straight away, first decision, please cite,
Yes.
which deals with the power of attorney holder of a partnership firm.
Before that, I would like to place section 24.
Correct, sir. Do you have any decision on the point?
Yes.
Power of attorney holder of a partnership firm.
Yes.
Two citations.
Citation is the last one. That is 2005, 7, written in hand.
Ashutosh versus State of Rajasthan.
Yes.
Okay. Because that would help, because by multiplying citations we will be on a road to nowhere. This you are saying, this is on the point.
Yes.
That the power of attorney, the partnership firm can have a power of attorney holder.
The direct decision to section 24 of the act. I am reading my law, section 24, then I will go to the.
Just. ଏଥିରେ ଆପଣଙ୍କୁ ଲେଖିବା କଥା କଣ କହିଲେ? Okay. Partnership. Section 24, you are
Yes.
saying. 24 years are there and 24?
Yes. Effect of notice to acting partner. Notice to a partner who habitually acts in the business of the firm of any matter relating to the affairs of the firm operates as a notice to the firm, except in the case of a fraud on the farm committed by or with the consent of that partner. Then 25 is the liability of the partnership that is shown.
You show from your notice, it is
Yes.
section 24 notice.
Yes.
You show from your notice that it is a section 24 notice.
Yes, I'm placing that decision of
Yeah, notice आगा. अपन एक fact में आरंभ करें.
Yes.
24 है section 24 notice में कोड है देखो.
Yes. You Lordship may see my additional affidavit.
Yes. WPC 31548.
Yes.
Yes. Additional affidavit. Yes. ଆପଣ ନୋଟିସ ଟାକୁ ସେଠି କଣ ପାଉଛନ୍ତି? ନୋଟିସ ତ ଆରମ୍ଭରୁ ଥିବ ସେ ତଳୁ ଆପଣ ନୋଟିସ ଟା କାଇଁ
କାଉଣ୍ଟରରେ ଦିଆ ହେଇନଥିଲା।
ଆରେ ସେଇଟା ତ ସେମ୍ ଆପଣ ତାଙ୍କ ଡକୁମେଣ୍ଟ ନୋଟିସ ହେଲେ ହେଲା ଆପଣ ଯୋଉ ନୋଟିସ ରେ ଦେଇଛନ୍ତି ତାଙ୍କୁ ସେକ୍ସନ 24 ନୋଟିସ ସରିଲା ଆଉ
Lordship may kindly annexer
କେତେ ଆନେକ୍ସର ମାର୍କିଂ କରତେ ହେଇଛି ସେଟା?
Yes, annexer F/3.
F/3.
Page 78. You got that. Mrs. S.G. Pandya and
So that is not a notice to the managing, what is that called? Acting partner.
Yes. No, the
sir, your argument is you have issued notice to acting partner in under section 24. But this is a notice to the farm. So that is how it leads to the question whether this notice to the farm is sufficient to all the partners who are being made liable in the that OPDR proceeding.
Yes.
So upon say 24 notice to dekha acting partner.
The notice has been issued to the farm.
Then kahinki, then why you are sir, let us, sir, you undertake the journey.
Page 89.
So now if you look at 79 and 80, yes. If you are saying that 79 80 of your this it starts at actually 78 annexer F/3.
Yes.
So either you say annexer F/3 is the section 24 notice, or it is not a section 24 notice, because now you are saying that section F/3 is not a 24 notice. F/3 is a notice to the farm. To the farm. So now you have
served on the power of attorney holder. That is at annexer F/3.
So there lies the problem, sir. That I have been asked from the day one when you have started raise this point. I have been trying to ascertain from you that if you are standing by the words, whatever has been briefed to you, that they have issued notice to the power of attorney holder, then please cite a decision where the power of the partnership firm can be represented by the power of attorney holder. The reason being section 4 and 5 is not a legal entity. Possibly it can be argued. Now you will fall back upon section 24. Section 24 is not power of attorney holder, it is the acting partner. So if you say that we have need to issue notice section 24 or falling back upon section 24, we have issued notice to acting partner, then you show that notice, not the notice to the farm. Because you must understand, Mr. D.N. Lenka, AGA, care of court number 9, suppose. Now the notice comes to the court number 9, but it is not served on Mr. D.N. Lenka. It cannot be a notice to Mr. D.N. Lenka. I hope you understand what I am saying. It's a rough example, very rough example, but we have a problem now that a partnership arm is to be served by section 24 notice, acting partner. Because if you are falling back upon section 24, then at least you have to show 2 ingredients, as I told. One, the person who has issued notice is the acting partner, and the rest is to follow. So for acting partner, 24 defines who will be the acting partner, who can be treated as acting partner. But F/3 is not to acting partner. F/3 is to the farm itself. So harm itself means all the partners.
The harm represented by the
Power of
patent
attorney
holder, also a partner.
You
He
are
also a partner.
You are again following up back on that. That power of attorney holder issue still remains. Still, still that is the vexed issue whether power of attorney holder can represent the firm, whether he has been appointed. Because yesterday we have examined even to the power of attorney that document you are relying upon.
He is also equally the partner.
Correct. But then you have to fall back on a provision that issuing notice to one partner is enough.
Yes, that is section.
So now 24 is acting partner. Then so which notice first you are relying on? Which is the notice to acting partner? 24 notice. But anyway, you are saying it is annexed by 3 is the notice.
Your Lordship, I am vigilant. The firm executed the contract with the state government. And on behalf of the firm, one of the partner became the power of attorney holder and he executed the agreement on behalf of the firm. So notice was served to the partner come power of attorney holder.
So you must kindly appreciate Mr. Lenka. You did not execute the lease deed with you executed, you have mentioned. With whom you have executed the lease deed, you have mentioned in the document itself, you have signed. Now you cannot change your colors. Kindly look at the document with whom you have executed. So by making a statement or the OPDR authority now saying you or the mining authority does not change it. Again, look at with whom you have executed. It is mentioned very clearly. You look at your document.
Power of attorney holder.
No, you look at the document.
Yes,
list it. 3/3. Page your document. 21. He has filed it at 80.
Yes.
He has again filed it. Additional affidavit.
Yes, madam.
Look at it, Form K. It is statutory form.
Model form.
Not model form, sir. Statutory. It is not model. Form K is Rule 31 of the MMDR Act.
Yes.
Look at the left-hand margin.
Yes.
Read it.
When the leases are more than one individual.
Read it. From the top now. This indenture made this 3rd day of February 1995. Read that.
Between the governor of Orissa, the president of India, hereinafter so state government, which expresses solely. Sri Kanta Prasad H. Pandya.
So now you need not read further. So you have executed the lease deed with as many as 10 persons.
Yes.
Correct?
Yes.
So you show from the lease deed.
Yes.
That because you are making a contrary step that you executed a lease deed with the power of attorney holder.
Through the power.
No.
Yes.
It can be. It can be, Mr. You can be. It can be.
That is the only record your lordship.
Yes, is it not your record?
That is on
though you are reading 10 persons, you are saying that true.
Can you read further? 10 persons are there. One of the partner, Kanta Prasad Pandya, who is the power of attorney holder, has executed the agreement. That's his signature.
Excellent, sir. But you have executed the agreement with how many persons? That is the question. Who has executed more? You have entered the lease deed.
Yes.
You have granted the lease to as many as 10 persons, not one person.
No.
Even
state government.
Sir, kindly read 18. I have to record your submission then.
Yes, your lordship may record.
Yes. This submitted by Lord Stamson for the AGA for the state that the state has entered into a lease agreement.
Yes.
With one Sri Kanta Prasad H. Pandya, son of late Hirji Dhanji Pandya, is it about, by lease deed dated 3rd February 1995. He relies on Annexure C/3 filed on behalf of the state as additional affidavit by the opposite party number 3, Deputy Director Mines, Joda. The lease deed reflects thus.
One line your lordship.
No.
Power of attorney holder.
Sir, the question, I cannot change my question, sir.
No, that is
sir, I cannot.
I will not do that. No, no,
Not,
your
I have, my question is very specific, sir. With whom you have entered the lease? You are saying that you have entered the lease with power of attorney holder.
power of attorney holder
Sir, you, sir, ଆପଣ ଟିକେ ଧୈର୍ଯ୍ୟ ଧରିଲେ ହବ।
of Messrs.
Mr. Lekha, ଆପଣ interrupt କରନ୍ତୁନି, interrupt କରନ୍ତୁନି, ଶୁଣନ୍ତୁ ଟିକେ। Because my question is specific. I cannot change my question at your instance. These are facts. I cannot improve or I cannot, even if you assume that I am improving, I am not, I cannot also. Please read in form K, the statutory form K has been annexed, marked as annexure C/3. C/3 by the deputy director, that miles, which is reproduced herein. This indenture made the third day to Neki, second page porjanta, paragraph Mr. Hargobind Pandey others porjanta. Should page 18 or 19 rachi, additional affidavit.
Yes.
Annexure C/3. Yes. It is submitted by Lord AGA that the state has entered into agreement with the power of attorney holder on behalf of all the lessees. That is your submission. On the face of it, on the face of it, that this such contention is erroneous and has to be rejected. It may be that the power of attorney holder has signed on behalf of all the lessees in the lease deed, but the recital of the lease is signed by the collector Kendujar on behalf of the
state,
state government. On behalf of the state government, which was entered between the governor of Odisha and the lessees, which are 10 in number. It is further submitted that the notice to the lessees is in terms of section 24 of the Indian Partnership Act 1932. Section 24 is reproduced here. The Lord AG is asked to show the notice to the acting partner as contemplated in section 24 of the Indian Partnership Act. It refers to annexure F/3, annexed to the additional affidavit filed by the Opinabhoti Deputy Director. That is demand notice dated 2/9/2017, which reads thus. Pass to Lekhidev, Office of the Deputy Director to Neki, 2 and 1 para. Reading of the said demand notice makes it clear that the notice was not issued to the acting partner as contemplated in section 24 of the Indian Partnership Act, but it was to the to MS M/S H.G. Pandya and others at Post Bodville, Street, Kendujar. Yes.
Against whom the lease was granted? By the annexure.
Submitted by the Learned Counsel for the petition.
By annexure B/3.
Learned AGA. Mr. Palit, you don't mind, because it will save time. I'm recording the submissions. I should have recorded your submissions first.
No, in reply.
Yes.
But you can add at this stage.
Okay. That the said notice is to the to the farm which had been granted the mining lease. Yes. In fact, that I have quoted actually. Upon the first paragraph, I have quoted on it. Yes.
So,
the Lorded Counsel for the Lorded AG relies on the section or two section partnership act related 24. 24. I would 24 I have put it. I would have put
24. 24 and 25.
24 and 25.
Yes.
The Lorded AG is also apprised of the provisions contained in the Partnership Act. That is section 2E. (18) and 18 of the Partnership Act. Yes. It is submitted by the Lorded AG that the partnership firm is represented through a power of attorney holder,
Who is also
a
partner of
lessee, who is also a partner in the partnership firm. The Lorded AG is apprised of the provision contained in paragraph section 4 and 5. 4 khali kar diye, paragraph 4 of the Partnership Act and the decision of the Honorable Apex Court in Malabar Fisheries Co. versus IT Commissioner Kerala, AR 1980 Supreme Court 176, and Comptroller and Auditor General versus Kamlesh Vadilal Mehta, colon into bracket 2003, bracket closed to SCC 349, which are in the chain of decisions and still good law that a partnership firm is not a legal entity, like a company. It is a group of individual partners and the property belongs to all the partners constituting the firm. In the case at hand, it is a lease deed entered between the state, entered by the state, with 10 persons mentioned in the lease deed itself. Stop. Yes. AR 2005-7 SCC 308. Last
yes, sir. That one paragraph 10, I am placing that.
2005-7.
Yes. That is under section 24 of it. I am placing that.
Just 1 second. More point of view. Yes. But Mr. Lekka, but I have already noted that there is no section 24 notice here. Because if you pitch it up that high, then suppose it is a section 24 notice, at least
Let me
the basic you have to show that. Look at
let me place.
para 12 is the para 11 and 12.
From 10 I'll be. Both the contentions raised by the learned counsel appearing for the appellant have absolute no merit. Now, it is not in dispute that a decree was passed.
Got it. So this is regarding execution of a decree in a suit where partnership firm is a party.
Yes.
So that we must not forget. Yes. They are already parties there. Yes.
It is not in dispute that decree was passed against the firm in which Srimati Swanso was also a partner under the provisions of the Partnership Act.
So here, which is the decree not to be executed?
A judgment, my lord. It's a demand. Here it is a demand. Here it is demand. Let me place, my lord.
No, sir. Please don't pretend that I am not allowing you to place.
No, I am not pretending.
So we can laugh at each other. So kindly listen, sir. You are saying that in the execution of a decree, when the notice was served to the section 24, this partner is called
Dhanavanti.
No, acting partner. Dhanavanti ho ki Gunavanti ho. Forget the name. So now the court says that if the execution, the decree after in the suit, the partnership firm is a party. There is a decree against the partnership firm. During execution, it is executed against the partnership firm. Notice is issued in the execution, and notice goes to the section 24 acting partner. That is the issue the court has answered. Now the partnership firm suppose say that we have not received notice. Correct? Then what is the answer? Then the court says, since you are a party in the suit, the decree is against you, and the execution is filed against you and against the served on the acting partner, that is how it is sufficient. So just before reading 10, 11 and 12, just look at para 2. 2 and 3. Get the facts actually. I know. I never intend to, interrupt you or not to listen.
No.
Kindly read 2 and 3. So that is how. Before reading 2 and 3, so I gave you the introduction.
The unsuccessful appellant in SP Civil Execution First Appeal Number so before the High Court of Rajasthan is the appellant before us by special leave. The appeal is preferred against the judgment and final order dated 12/11/2003 passed by the High Court of Rajasthan in the SP Civil Execution First Appeal Number 2 of 1992, whereby the appeal preferred by the appellant was dismissed. Briefly stated, the fact are that a decree of rupees so-and-so was passed against the state of Rajasthan on Ete in respect of the construction work of the irrigation department under the Arbitration Act in case of 4 so-and-so entitled Sharma and Company State versus State of Rajasthan. The said company filed execution and recovered rupees Ete as against the said amount. 2 securities were furnished, one by Sri Gurbachan Singh so-and-so and securities were furnished so-and-so. Along with the aforesaid surety, another by Srimati Kamala rupees so-and-so. Along with the aforesaid surety bonds, house number so-and-so, Sri Ganga Nagar was also furnished against the security. The appeal preferred by the state of Rajasthan against the aforesaid judgment and decree was allowed ex parte by the High Court. An application under Section 144 CPC was moved on behalf of the state, which was registered as the civil miscellaneous case number so-and-so. The state of Rajasthan impleaded Sharma and Company, Srimati Kamala Devi and Sri Gurbachan Singh, and responded to the said proceeding. Srimati Dhanavanti Devi, the wife of Sri Shivlal Sharma, was the exclusive owner of the house bearing number so-and-so. She executed a will dated 7/12/1983, bequeathing the aforesaid house in favor of her daughter's son, Asutosh. Sri Dhanavanti Devi died in so-and-so. It is stated that the probate proceedings are pending in respect of the aforesaid will, the district of Sri Ganga Nagar allowed the application filed by the state of Rajasthan under section 144 CPC and held that action can be taken against Srimati Kamala Devi and that applicant was entitled to interest from Sharma and Company and that the aforesaid application.
So why I said to read forth, just read forth paragraph 4 last line.
Yes.
The High Court held that the will was prepared to defraud the creditor and not with the intention to bona fide prepare the property to the appellant.
Yes.
The daughter's son agreed by the said judgment, the appellant prefers the other. So why I say that when maybe little get irritated. So the point is
Sir.
no, the point is no. Kindly appreciate this. Because I'm here to assist you also. It's not the both ways. In a suit, a decree has been passed.
Yes.
They are the parties.
Yes, sir.
They take the plea that in the execution and now the property. The property supposed to be executed. Correct.
Along with the company, both the partners. That's
Both the partners are implicated.
Now
they
can take the point turn
they are saying that for the execution of that decree against this property, that is another. There is another branch. What they did by a will, that property is bequeathed. So that is only to frustrate the execution. That is another thing. But in that case, how the party who is at the stage of execution will say that I am not aware of the decree, I am not noticed. They are made a party also. To that extent, what Mr. Palit says is, in fact, suppose now you make all the lessees a party, 1 to 10, all the Pandyas or whoever is there, and also this HG Pandya.
Also notice.
Also you notice everyone. Then it's a different thing. So that was the question to you, that in case of execution of decree, and when everyone is a party in the case, in this particular case, all of them are party. In your case, you are saying that they need not be party. The power of attorney holder has received. Of course, it is not a case of a suit, it's a notice in a particular matter. So since we have issued notice to power of attorney holder, that is enough. Now can you read further? So at least to get the facts.
Yes, sir. Under the provisions of the Partnership Act, one partner is the agent of the other. The partner is always liable for partnership.
Kindly just, Lenka, since it is the only judgment, let us read it in detail.
Yes.
So read also then 6 questions of which was raised before the trial by the Supreme Court. 6
Land Council appearing for the appellant raised 2 questions for consideration. A decree cannot be executed against a partner when the decree was against the partnership firm. A decree cannot be executed in violation of Order 21, Rule 49 of 50 CPC.
And 50.
50.
And 50 CPC.
Then Lawrence Council appearing for the appellant submitted that Srimati Dhanvanti Devi had purchased the house number so-and-so from the state of Rajasthan on Ete, and that except Srimati Dhanvanti Devi, no other person, including her husband, had any right, title or interest in the said property. It was further submitted that the proceedings in the instant case were initiated in utter disregard of the provisions of Order 21, Rule 49 and 50 CPC. And therefore, the procedure adopted as against the property of Srimati Dhanvanti Devi was manifestly illegal and is liable to be set aside. It was further submitted that Section 53 of the Transfer of Property Act 1882 does not supply on the facts of the case and that the will was executed bona fidely by Srimati Dhanvanti Devi on 7/12/1983 in favor of the appellant and that there was no question to defeat the claim of the respondent. For contra,
this is important for you.
Yes.
What was the argument? Counter, yes, please.
For contra, Mr. Aruneshwar Gupta, an additional advocate general, appearing for the state of Rajasthan, submitted that a partner of a partnership firm.
So this should be the submission of Mr. Lenka, Learned AG.
Yes, ma'am.
Yes.
Partner of a partnership firm is always liable for partnership debt.
Kindly just mark these words.
Yes.
Partnership debt unless there is implied or express restriction, and that where the transfer is made to defeat the execution of the decree, then in those cases, provision of Order 21, Rule 49, Rule 50 CPC. So what I was telling you, Mr. Lenka, that is a future event. You will cross the bridge when they will be. Suppose they start they start quarreling amongst themselves. They deny or purposefully they avoid of payment of any decree against them. So that is a future thing. But here, what I wanted to tell you, sir, Section 24, notice to partnership firm. First, you have to find out that whether he was issued notice. Here, the problem is everyone has been noticed. Actually, it is different. Yes, while replying, kindly read. While replying to the arguments advanced by the Learned Counsel,
the Learned Counsel appearing for the appellant in regard to the fraudulent transfer, Mr. Aruneshwar Gupta submitted that every transfer of immovable property made with the intent to defeat or delay the creditors of the transferor shall be voidable at the option of any creditors so defeated.
Mr. Lenka, I think all three of us will agree. You, Mr. Pandit, mean that this part is not their subject matter of.
We have
Because
not come to that.
no, I mean long future. Kepe kon hobo seta tolga katha, but here then kindly
Your Lordship was saying para 12.
10, 11, 12. Tinta jaga padibo.
It is 10. Both the contentions read by the Learned Counsel appearing for the appellant have absolutely no merit. It is not in dispute that the decree was passed against the firm in which Srimati Dhanwanti Devi was also a partner. Under the provisions of the Partnership Act, one partner is the agent of the other. The partner is always liable for partnership debt unless there is implied or express restriction. In the instant case, notice was duly served on Srimati Swansho and her husband, house number 8. And the Partnership Act 1932 can be usefully referred to in the present context.
से प्ली नियंतु हमें प्रॉपर्टी आमर नुह प्रॉपर्टी ताकर प्रॉपर्टी से सो एक रु 10 अछंती सो आमे कई सेते बाटा ट्रैवल करिया पड़तो आमे तो बर्तन बेसिक अछु आमे गोटे माइनिंग डिमांड रेज करलु अनेक्सर 8/3 रे बट नाउ to apply this decision also, if you read now para 10, with the facts, para 3 and 4, notice has to be issued to someone like Dhanwanti Devi and his husband. Here the notice has not been issued to Dhanwanti Devi and her husband. It is exclusively to the firm. Because to start with that, I asked you that if you have a section 24 notice, what is the acting partner, 24 notice to acting partner, then let us rely on that and let us start it so that he can have an answer. Because if the notice is not there, then I mean, traveling in that path to search for the notice is no point.
Our case is notice was served, issued in favor of the partnership firm through the.
And all these persons are parties in the suit.
Yeah, in this case.
In Dhanwanti Devi, in fact, it is a clear case where they knew what is after execution they have started it. I don't know, the court has not given the dates. Most likely the will was made after the execution or after the decree was passed against them.
Yes, sir.
Those things are, anyway, you rely on para 10.
10, 12, man. 12 also.
10 and 12, not only 12.
12 and 13, both.
12 and 13.
12. Section 24 is based on the principle that as a partner stands as an agent in relation to the firm, a notice to the agent is tantamount to the principals and vice versa. As a general rule, notice to a principal is notice to all his agents.
But what about Mr. Lenka?
This one.
His judgment has two aspects. One is 24 and other is that it has been noticed served to all.
They were implemented.
They have to be.
Yes.
They have to be, sir.
Well,
they have to be, the reason being, they have to be implemented, which was our discussion from the day one when we started, that there is no difficulty in implementing the lessees. Or notice, here not implement it and noticing the lessees. Because let them pay or let them decide how they will behave, how they will react to your notice.
Can I take a lordship's leave minutes? I'm
Yes, yes.
Called in another bench.
Yes, yes.
I'll just.
Yes. Mr. Lenka has enough material for the day.
Again?
Mr. Lenka has enough material for the day.
But-
You are not required to answer today also. Yes.
Then as a general rule, notice to a principal is notice to all his agents, and notice to an agent of matters connected with his agency is a notice to his principal. Then 13. Under section 25, the liability of partners is joint and several. It is open to the creditors of the firm to recover the debt from any one or more of the partners. Each partner shall be liable as if the debt of the firm has been incurred on his personal liability.
I mean, there can't be any second opinion on this.
Yes.
Have you felt that section 25 we are
No.
discussing? No, you are discussing, sir. They say that the partners, the lessees have not been noticed. You are saying the lessees are partners. There is a power of attorney executed by the firm against one some HD or against one HG Pandya. So that is sufficient. We have issued notice to HG, and we need not. So there lies the now the discussion and the dispute. So whether they are liable or not, that we are not discussing. They were not
It's a
discussing.
subsequent.
Because of course they may deny, or they may together 10 of them, they may start bickering against each other. That we cannot say.
And I've also cited all those decisions.
Then put it. No, any other paragraph from this decision?
No, man.
Okay.
This one.
If you take this judgment, Ashutosh versus Rajasthan also, if they have discussed with also that order 21 rule 50, 49 and 50, because that is at the stage, again at the stage of decree. If you now we are at a stage where you are raising a demand.
Then I am limited purpose, only for the purpose of notice.
24, section 24 you are saying.
I am not.
But the problem is that you have issued section at annexer 8/3, page 78, which just you showed, because I asked you that where is the section 24 notice?
Yes.
Or which can be construed as a notice to the under section 24. They are actually, in case of Ashutosh versus Rajasthan, Dhanvantari Devi has been issued notice. Here the farm has been issued notice, 8/3. That I wanted to draw your attention. Because if you issue notice to someone, this notice is to the farm. You are saying it was served on the power of attorney holder. I think that is your case. Though notice is to the farm, it is served to the power of attorney holder.
Farm.
That they are saying that let give us the notice so that we can have our say to the demand.
And after the notice is solved by the annexer J/3, the Lordship will see he received the notice. The power of attorney holder.
Yes, yes.
Accept notice.
Yes,
Then
they are.
Then by virtue
annexer A/3 also names 10 persons.
Yes.
You are saying out of 10, if one is issued notice, so 10 रे से ଅଛନ୍ତି ନା?
ଅଛନ୍ତି ନା? ये भी
किए कहନି?
देवेंद्र पांड्या.
Two अच्छा. TH.
Yes.
So ଆପଣ କହୁଛନ୍ତି ଯେ 2 କୁ notice कले sufficient. ସେ କହୁଛନ୍ତି ଯେ ଆମେ 10 ଜଣ ଯାକୁ notice ଦିଅନ୍ତୁ. This is the point. Not because if you read that Ashutosh, para 22 देखो.
Para 12. Section 20.
नहीं 22. 22.
Yes. it is not in dispute that the decree amount of rupees so was received by the state and so. The dispute between the parties is only with reference to the interest.
So kindly stop there.
Yes.
Even Mr. Leka, they have paid it.
Yeah. The amount was
The person who has paid the decree now will say that I do not know. The same thing you are present, I think, in that matrimonial case. I think you are sitting in the court.
Yes.
He appeared in the execution, says that I have been proceeded expert, but he has appeared in execution. ସେଥିରେ ଗୋଟେ ଲାଇନ୍ ତା ପରେ ଅଛି ଜଷ୍ଟ ଆପଣ ତାକୁ ଯଦି received by state on 17/10 the dispute between the parties is only with the reference to the interest principal amount as on 17/10 and which according to the state was payable by the farm. Just read further.
Yes. A sum of rupees 61,890 was arrived as interest on it as on 17/10/1992. Mr. Anureshwar Gupta.
This you read please slowly.
Mr. Aruneshwar Gupta submitted that the state has been dragged into the court unnecessarily by filing a vexatious litigation by the appellant, and therefore the state must be sufficiently compensated by directing the appellant to pay the interest at the rate of 18% per annum on rupees so from 17/10/1992 till date. Though the argument of Aruneshwar Gupta appears to be attractive on the first blush, yet on reconsideration and reappreciation of the same, the said submission has no merits. Both the parties are in legal battlefield for all these years. The appellant has also succeeded before the trial court. The trial court has held that the will is genuine and therefore necessarily the appellant has to defend all further proceedings initiated by the state in various courts. Mr. Aruneshwar Gupta submitted that the interest amount of rupees so as on it put plus the subsequent interest shall be ordered to pay to the state without showing any sympathy to the vexatious litigation.
In 23 also, they have not accepted state's contention. So what I was trying to tell you, Mr. Linka, that even the state saying that we are dragged into the litigation, court has rejected. The reason being both have been fighting. So as normal litigants, everyone fights, maybe state or the parties. Even 23, the state has to wait for some more time to realize the fruits of the decree. Asking both the parties to continue the execution proceedings at this distance of time is also not proper. So there has to be a balance also, Mr. Lang. My point to you is that if you read para 22 or 23, 24, the Supreme Court is also conscious of the fact that like litigants, parties will fight, they will resist. That cannot be taken exception.
That you Lordship consider. Yes. Yesterday, your Lordship was asking for the amount that is in the said demand notice, page 81, the period of.
Period you have said I have noted.
Yes. No, that the each year amount has been indicated, page 81. Annexure A/3. From 2001 to 2010 and 11.
Annexure amount kete kouchanti?
Annexure A/3.
A/3, yes.
Page then page 81.
That we are just looking at.
Yes.
78 to
78
Yes, yes. We looked at that.
Yes.
Yes.
Another one point only I will place on that. The maintainability of the writ petition, because out of total 10 numbers of lessee or partner, only 4 have approached without implementing the power of attorney holder and also the other partners. So in that case, they are necessary and proper parties, they have not been implemented. In their absence, the consequence that is.
Let's go to it is submitted by the learned AGA that out of the 10 leaseholders, as mentioned in Annex 8/3, that is agreement dated as 2nd January 1990. 8/3 was just 1 second. Is it a C/3?
Lead it Annex 1 in the read petition.
C/3 which C/3.
Additional.
As indicated in the lease deed dated 3rd of February 1995. 4 have approached.
Only 4.
4 have approached. 6.
The other two read petitions.
Oh, अच्छा अच्छा. से कोची दावरी अच्छी read petition. अच्छा. ସେଥିରେ ସେ କହିବେ 2 has approached, 8 are not there. ଆଉ କିଟା କରିଛନ୍ତି ଆପଣ? 4 2 4 have approached and others have not approached.
They should have been
It is
included in this.
the response on an advocate on record for the petitioner submits that it the 2 writ applications. Out of the 10 leaseholders, 4 have approached together in 31548 of 2025. Nirmala Kantire.
Without implementing other.
And ଆପଣ 3ଟା ଅଛି ପରା 2ଟା କୋଉଠି ସେକେଣ୍ଡ ମ୍ୟାଟରରେ କି ଜଣ ଅଛନ୍ତି ଆଚ୍ଛା in WPC 31551 one of the partners, one of the lessees, and in WPC 31554 of 2025 another lessee. Mr. AGA का जो submission आउटरे पढ़िए. सेটা লিখে as per the সেটা agreement जो লিখলে নাকি as per the lease deed in form capital K. Approved and have not been made a party. Not been made a party. Three. In the change 3 writ applications have been filed. 4 lessees in one, and one lessee in each of the rest of the 2 applications. And one of the lessee in each of the 2 applications.
One lessee each.
After se number uda kar pakai debe.
That's all.
Any other case law? ଆପଣ ଯୋଉଟା କେ ଏଥିରେ ସାଇଟ୍ କରୁଛନ୍ତି ଏଗୁଡା ଏଟା କୋନ ଯିବା
ଠିକଟା
ଆପଣ କିଛି ପାଇଲେନି ଯୋଉ ପାର୍ଟନରସିପ ଫାର୍ମ ର ପାର୍ଟନର କ୍ୟାନ୍ ଏକ୍ସିକ୍ୟୁଟିଭ ପାୱାର ଅଫ ପାର୍ଟନର କିଛି ମିଳିଲାନି ଡିସିଜନ କାହିଁକିନା ଆପଣଙ୍କର ଯୋଉଟା ଆପଣ ରାଜସ୍ଥାନ ଯୋଉଟା ସାଇଟ୍ କଲେ ସେଟା ତ ନୋଟିସ ସେକ୍ସନ 24
ନୋଟିସଟା ନାଇଁ ଆଉ ଗୋଟେ ଦେଇଥିଲେ
ପାୱାର ଅଫ ପାର୍ଟନରରେ କୋଉଠି ଡିଲ୍ ହେଇଛି କି ପାୱାର ଅଫ ପାର୍ଟନର
yes ଆପଣ year 2005 that is second
ବସନ୍ତ ନହାଟା
yes May I read the relevant portion?
Yes.
The paragraph has not been mentioned here.
तो आपको पास बहिटा नहीं ये 2005 ରୁ ଆଣୁ ନାହାନ୍ତି ସେ ଆଣନ୍ତୁ ମୋର ପକ୍ଷରେ ସେଠି କହିଛି ସେଠୁ କୋଉଠି ଆଣିଲା 2005 Supreme Court. 3401. Oxford is
State of Rajasthan versus Vasanta Nahar.
What city is it? What city is it? What please?
Power of attorney. The grant of power of attorney is essential. Yes, sir.
Like, say, boy got to page 3401. Power of attorney. Straight away, point which I now find difficult to get a citation on that.
Yes.
Whether a partnership firm can have a power of attorney.
The last gote line can the execution of a deed of power of attorney, therefore, is valid in law and subject to the provisions of the Act, is not compulsory registrable.
ଆପଣ ସେଠି ଛିଡ଼ା ହେଇ ଦେଖନ୍ତୁ ଆପଣ ତ ବସିଥିଲେ ଆପଣ ଦେଲେ ମୁଁ ପେଜ ପାଇଛି ଆପଣ ଯଦି ଭାବୁଛନ୍ତି ପେଜ ପାଇବେନି ବୋଲି ଦେଖନ୍ତୁ ପାଉଛି ଆଣିନାହାନ୍ତି
3401.
ଆପଣ ଏଇଟା ଦେଖୁନାହାନ୍ତି ସେମିତି କଣ କରୁଛନ୍ତି ଆରେ ଏଇଟା ଦେଖିକି ଆଣିବେ ପେଜଟା ଆପଣ ଦେଖିନାହାନ୍ତି ଯାଆନ୍ତୁ 3401 ପେଜ ଫେରିଦେଲା
ଏଥିରେ ସେ ଗୋଟେ କ୍ୱେଶ୍ଚନ ଉଠେଇଛନ୍ତି ଯେ ଏଟା ନୋଟାରୀ ପାଖରେ affidavit ହେଇଛି, it has not been registered, the power of attorney.
କୋଉଟା
They have raised one question in the requisition.
ନାଇଁ ଶୁଣନ୍ତୁ ମୋର again I am again this sir ମୋର କାମ ନୁହଁ for the constitutional court to deal into that.
But they have raised the question.
So ସେ ତାର consequence ଅଛି ମୁଁ ତ deal କଥା ହେଲା ଯେ ଆପଣ ରେଜିଷ୍ଟର କର ଠିକ ହେଲେ ଠିକ ये ବହି ଆଣୁନାହାନ୍ତି ଠିକ ହଉନାହାନ୍ତି ପଚିଶଶହ ଯୋଉଠି ସରୁଛି 2536 ତା ପର ବହିଟା ଆଣୁ ତମର ଅନରେଜିଷ୍ଟର୍ଡ ଫାର୍ମର ଆଜ୍ଞା କନସିକ୍ୱେନ୍ସ ଅଛି ମତେ ବହି ଦିଅ You are relying on which paragraph?
Paragraph of the mention ହେଇନି
paragraph mention ହେଇନି
ସେଠି ଗୋଟେ ଲେଖା ଅଛି power of attorney ବଡ ବଡ ଅକ୍ଷର ଲେଖା ଅଛି power of attorney.
ଏଇଟା କଣଟା ଆପଣଙ୍କର କେସ୍ ମାଇଣ୍ଡ ନା କଣ ଏଇଟା ଅନୁପାତ
ହଁ ଏଇଟା ନାଇଁ ମନୁପାତ୍ର ନୁହଁ ଏଇଟା ଆମେ ଡାଉନଲୋଡ କରିଛୁ
ଇଣ୍ଡିଆନ କାନୁନ
only limit
according to you this decision is on the point
on they have raised a point in their picture that the power of attorney has not been registered under Registration Act 1908. So our stand is power of attorney is not compulsorily registrable. If it is notarized, that is sufficient. And that derives from section 85 of Indian evidence.
Sir, since I have already told you I have made up
Then you are,
I have said in open court that even if they say that whether, because I am not going, because I will be going to the stage of notice.
then you
At the stage of notice it will go. So whether the power, you will again notice the power of attorney holder or the lessee or the firm, section 24 notice to the acting partner, that is up to you. Because this court is not to specify that. And the reasoning, as I told you, that if I start writing a judgment on this, dealing with this aspect, there has been no factual determination by any of the trial, the authority. Unless there is a determination, but to some extent, either favoring you or favoring them by authority, then appellate court, it becomes very difficult for this constitutional court to deal with the matter because everything is fluid. I cannot start taking evidence and hear each of the parties on all the aspects whether notice is sufficient or not, and whether they deny or they are liable to pay, and who is liable to pay, how much is to pay, all these things.
Then you're not sure.
So at least there should be some kind of a application of mind by the authority regarding these issues.
Yes.
आर मैं तीन टाइम मैटर रे जो जजमेंट अपन पर कॉपी खिला दे परिबे
हां एटा जो काजी बात
the writ applications.
The comptroller then not. I would tell Manu.
Report पागे अच्छी. आर तीन टाइम बैच मैटर रे जो जजमेंट.
I would tell Manu about that. You're right.
ये मालाबार दरकार नहीं हो. Where the other three matters where you are appearing, Mr. Lenka, both Lenkas were.
Yes.
Malabar so it was.
9, 6,
Malabar industry or Arata, Doctor.
Comptroller.
ସେଇଟା ଯୋଉ ଏଜେଣ୍ଟ ସବମିଶନ ଟା ପଛକୁ ରହେ କଣ ଆରମ୍ଭ କରନ୍ତୁ ସବମିଶନ ରୁ ପେରେଣ୍ଟସ
ଏତେ ବର୍ଷ ନାହିଁ
ସେଟା ଖାଲି କମ୍ପ୍ୟୁଟରରେ ମିଳିଯିବ ଯେ 96 ପାଖରେ ଅଛି
9693 ତାର ନମ୍ବର
9693 the writ applications.
I'll take a break on this.
Yes, please. The writ applications are listed as directed by. Yes, better have next. Thank you. ଗୋଟେ heading କରିଦିଅ। The writ applications are date of hearing गुड़ा ऊपर से लिखिए। Date of hearing काली भी continue करता हूँ। Date of hearing अभी गोटे काली गोटे गोटे काली गोटे आगोटे दिन hearing होते। तो गुड़ा को लिखिए। The writ applications since it involve a common question of law arise out of similar set of facts are taken up together, heard, and also disposed of. Ajiro order of achieved hearing of the WPC number 31548 of 2025 has been filed by 4 petitioners challenging the certificate case number 30 of 2018 under the OPDR Act and the warrant of sale dated 17/9/2025 into bracket annexer 10. The prayer made in the writ application is reproduced here. Here, page 17 रे अछि issue writ of certiorari लेखि C. ABC. The writ application suffer lekho to writ application 31551 of 2025 has been filed by the petitioner challenging the certificate case केते दाखल करा let's say challenging the same certificate case ସେଥିରେ ସେଲ୍ ଡିଟ୍ କେତେ ଦାଖଲ warrant of sale अलगा भूली गले से 17/5 17/9 कहीं आपण को टाइपोग्राफिकल मिस्टेक हिची 17/9 तो अछि एथिरे आ सेथिरे केते अछि माने सर केते अगर तल 5 जदी हिची तले मु डाक्टर बोलतो 17 ठीक है 17/9 20 25 चल चल से writ petition W 31551 of 2025 has been filed challenging the same certificate case as well as the warrant of sale stuff. Then para the prayer quote कर देता है. The prayer made in the writ application is reproduced here. अपन देखो तो WPC 31554 of 2025 has been filed. Yes, Ms. Pradhan, look at it. You should be on your toes. Certificate case 30.
30 of 2018.
The certificate case number 30 of 2018. The demand amount by order dated 6/7/2019 into bracket annexer 7, comma demand orders plural करते हैं demand amount by orders dated 16/7/2019 into bracket annexer 7, comma 11/4/2025 into bracket annexer 8, and warrant of sale by order dated 6/9/2025 and 17/9/2025 stop. प्रधान आगुरी कोटा ऑर्डर हेतिला जेतरे आगुरी आपण सबमिशन गुडा को नोट हेतिला Bisect. Bisect 26 order को जाके same constitutive एकाठी ଅଛି सेटा can reproduce it. इतरे Mr. सुबीर पाल जोटा रहिबे तापरे Mr. DN लेखा बुझियो modified. The allotted counsel for the petitioner has been heard extensively on bisect 2026. Thereafter, the allotted AG has been heard on 19/3/2026. इतने लिख लेने की सीनियर काउंसिल आउट डेट ऐड करते 23/4/2024 पिटिशनर को डेट अलग कर दिया the allotted AG has been heard extensively on 11/5/26 ना पूर्व जो डेट थी 11 मास पूर्व डेट था लीगल जी हाँ 23/4 हाँ ठीक है 23/4 AG है ना 23/4 11/5 है आज The matters have been listed in a separate special list as per the orders of the Honorable the Chief Justice in the administrative side. Dated court orders of the Honorable the order dated 21/26 of Honorable the Chief Justice in the administrative side. Paragraph 3 of order dated 5/26. 3, 4. 3 and 4. Yes, petitioner submission. Now, the learned AGA submission, the learned AGA has referred to the provisions of the Partnership Act. Particularly section 24. সেটা কোন মতে লিখি সেকশন সেটা তো সেটার হয়ে গেল আর आईए नंबर एथरे स्टेट रा आईए नंबर कहि पे मिस प्रधान स्टेट केते आईए फाइल करछि 25 हेतिबो नै कि 19802 19802 आपण बनाई 23242 23242 of 2025 vacation of stay. So, IA 23242 of 2025 has been filed by state arising out of WPC number 31548 of 2025. IA dash arising out of WPC 31551 of 2025 and IA dash arising out of WPC 31554 of 2025 for vacation of the interim order. To all the IAs, copy of the order dated 10/12/2025 passed by the Honorable Supreme Court The para 4 of our judgment to para 4. Para 4 reproduce for the marriage. Blue must blue tick of those. Including should I copy paste for them? You don't have to type it again. In response to the submission of the counsel for the petitioner regarding sufficiency of notice before determination of the demand raised by demand notice dated annexure F/3 by demand notice 2/9/2017 issued by the office of the Deputy Director of Mines, Joda Circle. It is contended by the learned AGA that notices have been issued to the power of attorney holder on behalf of the farm oblique all the lessees Therefore, the notice has to be treated to be sufficient. Stop. It refers to the lease deed in Form K dated 10/2/1995 into bracket annexure C/3 to the additional affidavit to submit that the lease deed has been signed by the constituted attorney से ताको नाडा कोन कोचंती
Kanta Prasad.
कांता प्रसाद
Pandya.
कांता प्रसाद पांड्या on as power of attorney holder of Hargobind Pandya and others for all the lessees. On behalf of the Governor of Odisha, on behalf of Governor of Odisha for the state of Odisha, the collector Keunjhar has signed the deed. ଆପଣ କହୁଛନ୍ତି କାନ୍ତା ପ୍ରସାଦଙ୍କୁ ଦେଇଛନ୍ତି
Kanta Prasad Pandya
has been served the notice.
No, after his death, execute kala Kanta Prasad. After his death, Devendra Pandya.
After his death, Devendra Hirjina Hargobind.
Devendra Pandya, his son.
नहीं देवेंद्र और सेकंड पार्टनर तांकर नाटा रहा देवेंद्र हिरजी पांड्या देवेंद्र हिरजी पांड्या से जो डीटा केबे साइन हैला
सेटा दीटा तकर से दीटा गोटे 2010 रे आ गोटे 2012 अनेक्सर अछि
तांकर केते
सेटा होची annexure D/4 to the reply to regender.
जोथरे की हरगोबिंद कले
Devendra Pandya.
Sorry, Devendra. It refers to annexure D/3 to the regender.
D/4
to the regender. Reply to the regender filed by state to submit that Sri Devendra Hirji Pandya has signed on behalf of the lessees.
Yes.
He submits that sufficiency of notice on the lessees is achieved by serving the notice upon power of attorney Sri H.G. Pandya. Devendra Hilji Pandya, D.H. Pandya. Yes. The learned AG has relied upon to support his contentions regarding the power of attorney, the implications of power of attorney being executed. The learned AG has relied upon AIR 2000 Juda State of Rajasthan. एमती कौन मैंने देखी नहीं थी ना तो डिक्टेट कल समय पर सीरियल नंबर 2 तीन सबुड़ा का 3 4 5 है सबुड़ा का रिलाई कुछ ना खाली 2 3 दे देला जजमेंट में हां जोटा पावर पैटर्न ऊपर आपण तो पावर पर 7 टा कने दे दी पावर पैटर्न 2 खाली 2 3 देला हबो हां हां ताले 2 स्टेट ऑफ राजस्थान बसंतहाटा गोटे कहउछंती यस and AR 6 2 और 6 दे दियो on being asked regarding that section 4 the implications of section 4 of the Partnership Act interpretation and implication of the section 4 of the Partnership Act. The learned AG submits that there can't be any second opinion on the implication of the section 4, but we relies on the decision in serial number 7 Ashutosh versus State of Rajasthan 2005 7 SEC 308 Ashutosh paragraph 24 कते का कोथिला उतरे कहले paragraph 12 वो मुझे नोट करो 12 13 2005 7 SEC 308 or 1230 the learned AG is apprised of the line of decisions in which section 4 of the Indian Partnership Act 1932 has been interpreted. Two of them being Malabar Fisheries Company versus ITC, Kerala, colon AIR 1980 Supreme Court 176. And Comptroller and Auditor General versus Kamlesh Vadilal Mehta. Colon into bracket 2003 2 SCC 349. The said the proposition of law laid down interpreting section 4 is still good law. That is, partnership firm is not a legal entity. Is not a distinct legal entity, like a company. It is a group of individual partners. Accordingly, whether execution of power of attorney by the leaseholders giving giving such power to one of the leaseholders would have a legal consequence of notice issued to the said person, said power of attorney holder, as notice to all the lessees. Need not be answered in view of the ultimate conclusion of this case. In view of the ultimate directions to be issued in the present batch of writ applications. Time here. କାମ କରନ୍ତୁ ଆଜି କାଲି ରଖିଦିଅନ୍ତୁ 3ଟା ବେଳେ for further. So I could have completed, but I have to attend.
Your lordship, take your time.
So Pradhan, any matter you are mentioning?
38 item.
30 date you want a date?
And we wait.
38 38
Okay, on which date my lord?
Sorry?
Which date my lord it will come?
38 week commencing on 38 Mr. Barik.
Again. No, before vacation. I pray before vacation.
Before next week. But next week ଆପଣଙ୍କର ଅଛି already 125 ହେଇଗଲାଣି.
And divorce proceeding ଟା stall ହେଇଯାଇଛି ସେଇଥିପାଇଁ I am for wife.
ଛୁଟିରେ ହବନି.
ନାଇଁ ଛୁଟି ନାଇଁ ନାଇଁ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯିବ ଆଉ କିଛି ନାହିଁ ଖାଲି ତାର ଏଭିଡେନ୍ସ ଟା କ୍ଲୋଜ ହେଇଯିବ ଆଉ କିଛି ନାହିଁ.
ଦେଖିବା ସକାଳେ ଆପଣଙ୍କର ଏବେ ଲିଷ୍ଟିଂ କଲେ
କାରଣ ବେଶୀ ଟାଇମ ଲାଗିବ
ଛୁଟି ନାହିଁ ଛୁଟି ହେଇଯିବ ତେଣୁ ପ୍ରୋବ୍ଲେମ ହବ.
ସେ କେବଳ ଖାଲି ସେ ଆମେରିକାରୁ ଆସିବା ପାଇଁ ପ୍ରୋବ୍ଲେମଟା ହଉଛି ସେଇଥିପାଇଁ ସେ ରିଟ୍ ଟା ଫାଇଲ ହେଇଛି ଖାଲି ପର୍ଟିକୁଲାର ଡେଟ୍ ଫିକ୍ସ ହେଲେ ସରିଯିବ. You fix up a date so that
এটা ରଖିବେ the Lorette Daisy as well as the Lorette counsel for the senior counsel for the petitioner were heard for the this for tomorrow at 3 PM for further hearing. କାଲି ସେଟା ବୋଧେ କମ୍ପ୍ଲିଟ୍ ହେଉଛି କହୁଛି ଏଇଟା ଆପଣ ଯାতে ଲଗେଇବେ ସେ କାରଣ ବହି ଗୁଡାକ ଅଛି ବେୟାର ଆକ୍ଟ ଗୁଡାକ ପାର୍ଟନରସିପ୍ ଆକ୍ଟ ଆଉ